clerk, Mr. Cutter, will give the court cry, and then I will introduce the case and we will proceed. Are there any questions?
Nope, thank you.
Wonderful. Matt, I think we're all set.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the December 15th, 2020 sitting of the Massachusetts Appeals Court. My name is Eric Nyman, and I'm delighted today to be sitting with my colleagues and friends, Justice Vicki Henry and Justice Kenneth Desmond. And I will call the first case, which is Commonwealth versus Moken, 2018 P1530. And I will remind counsel that this case, with all of our cases, is being live streamed on YouTube and recorded on our YouTube channel. So please keep that in mind. Also, as I've told counsel, you may note that at times it appears that the justices are looking off to the side. That is not because we are not paying attention to your arguments. To the contrary, it's because we are simultaneously looking at the record, the cases, and other information pertaining to the case on our monitors. So with that background in mind, we will hear from counsel for the appellant, Attorney Suchecki.
Good morning, Your Honors. There are three arguments the defendant raises on his appeal. I'm going to focus on arguments 2 and 3. And in argument 2, the prior bad acts of the defendant were brought up by the defendant during his direct examination. And in our brief, we make the argument that the way the prosecutor crossed on those bad acts was damaging to the defendant, and it was more prejudicial than probative. And in this particular instance, the judge, there was no request for limiting instruction, but the prosecutor went to the substance of the event as opposed to just telling of the event. And the details she managed to extract from the defendant were prejudicial to the point where it was damaging to his case. And this was a really thin case in terms of it was just a he said, she said, and there wasn't a lot of evidence presented. It was just the testimony of the 6-year-old boy. And in that circumstance, the use of the prior bad act and how she crossed on it was damaging, in addition to the fact that she used it during closing argument. And
the Commonwealth argues on that point that she was really making the point that the defendant was willing to give false testimony, and that is an appropriate use of the prior convictions. What do you say to that?
I think that's just implicit in the ability to bring up the conviction. The fact of the conviction, I think, states that, and that's about the limit you can go to as far as instead of the details of it. I think there's a stopping point. I think if you bring up the details of that, this is a guy who got convicted of these crimes because he's chosen to, essentially, because he's decided to testify, he's exposes himself to the cross on the conviction. But at that point, you can only go up to a certain point. And I think in this case, you went too far. And the use in closing argument was made it exponentially so. So in her closing argument, if I could indulge the court, I'm just going to read what was said about it. She spoke of the defendant. You can evaluate the defendant's credibility the exact same way you evaluate the other witnesses. Think about his characterization of his loving, great relationship with Sherry, and then you come to learn that around the same time period, he was pleading to two different violations of a restraining order, where Sherry was the subject of that restraining order. That's his thought process. That is their great loving relationship that he even went on to describe for you, that he knew that there was a restraining order. He knew he was in violation of it, but apparently the law didn't matter when he wanted to talk or to see his son. Now, that was the other thing, was the mocking nature of it. And he may have been in a relationship for a longer period of time, but he was actually talking about that period of time, and to focus in on that in a very mocking way. And it was done also during the cross. It was done in a mockery, and it was disparaging. And I can understand the argument that where it says that, oh, it brings out that he's willing to lie or break the law. But that's, like I said, that's implicit in just being able to bring up the fact of the conviction, and the details of it is crossing a line.
But you're saying, you just used the phrase, when you bring up the fact of the conviction. Who initially brought up the fact of the prior conviction?
Oh, it was on direct. It was direct by the defense counsel in order to, blunt the exposure through cross-examination.
So you agree then that it's fair game, the defense having raised it, it's fair game for cross-examination. It seems to me your argument is just that it went too far.
Yeah, I think absolutely. I think that you can because if he's deciding to testify, he's going to expose himself to that. But it's only that you say, okay, he was convicted. Weren't you the person who violated the 209A order on such a date? Yes, but to go to the full details of it, and the cross was, it was good cross-examination. He managed to extract the way he responded to her made it more damaging, of course, but it was designed to extract more, and it was more damaging.
But I was under the impression from the direct examination that the defense did a little bit more than simply introduce the fact of the restraining order, or rather of the conviction. They did get into a bit of detail. Isn't that fair to say?
I think that bit of detail was accidental. I think the response of the defendant was not the response to the question.
Right, I agree, but a trial's not a script. So that,
obviously,
that information without objection came before the jury. That information having been elicited, again, why is it not fair game for the Commonwealth to explain context and to ask questions that might paint a different picture with regard to what was stated on direct examination?
I don't think it changes the picture at all. I think the purpose of the introduction was to show that he's the type of person who has prior convictions, not that this is a person who with the mocking that, oh, weren't you in love? And then in addition to the fact that he's willing to lie to see his son, the details of the particular. So she went below the surface, and that's too far. And I sorry.
Well, one, she couldn't have anticipated that he was going to say he was willing to lie to see his son. I mean, isn't that the obvious question? In one breath, he's saying, I'm in this loving relationship. And then in the next breath, he's saying, I have a restraining order where my wife is the victim. Isn't that a fair question that the jurors would want to answer?
I would stick to my main point. I'd say absolutely not. I think there's a point where you stop. I can understand. I mean, it's like blood in the water. There's a certain, you want to go there, but if she doesn't stop herself, then the judge needs to go and give a limiting instruction because it went too far. That's just too much information for the jury to deal with on that. And they're not mutually exclusive. One doesn't necessarily mean the other.
And was there an objection?
No, there were no objections.
And so how can we ask the judge to sua sponte get involved if it wasn't even obvious to the defense counsel to object?
I see your point. But at the same time, I'm just saying if she didn't stop herself and the defense counsel didn't object to it, it's still a substantial risk of miscarriage of justice because this case was so thin on there wasn't a lot of evidence here, and the exposure to that and the details of the conviction was very damaging to him. And the other argument that I'd like to go into is not the layers of the first complaint, but specifically the misstatement of.
Before you switch to that topic, I did have one more question on prior bad act. The Commonwealth argues that the defendant may well have had a tactical reason for requesting a limiting instruction. I wondered what your response to that is.
I didn't follow. I read it and I didn't follow that. I don't believe that it was a tactical error. I think that she or he, I forget who it was just as surprised as she to have him respond the way he did and had to roll with it and work his case the way it was. I don't think it was a tactical error. I think that had he remembered it, there's no harm in saying that he can only use it for a limited purpose. That could only benefit him. So I think it was an omission, if anything, and the judge should have heard it and seen that it was going too far with the bad acts.
I mean, I think they were arguing, I'm looking at page 28 of their brief, that it was a tactical choice not to focus the jury's attention on that evidence.
Yeah, I would disagree. I don't think that I don't see that. I don't see that at all. So as I was saying, as far as the next argument, as far as first complaint, when the judge initially brought it up, he mistakenly called it hearsay, and that you could use it for the statement for the facts asserted. And although he did subsequently correctly give the first complaint instruction, there was no correction. So there's a case cited in the brief where if the jury is left with alternate instructions, you don't know which instruction they're actually going to use, and that's in that particular circumstance, it needs to be reversed because you don't know what they're relying on, and they were told they could use it for the substance and not for just the fact that he had told for liability and credibility.
When there is an ambiguity or a question in the record as to whom the correct first complaint witness may be, whose responsibility is it to make that determination?
Who the correct first complaint?
Yeah.
Oh, in this circumstance, I think the judge did it properly. He did a voir dire to find out who was the first complaint, and he examined the mother, and I thought that he did it fairly. I don't mean to be contrary to anything that's in the brief, but at the same time, I thought the judge is responsible and to find out. He heard an anomaly, and he called a voir dire to make sure that he was absolutely clear on the record, and that I personally don't see that there was anything wrong with the way the judge handled that. I think that's exactly who should decide in that circumstance.
But your issue is the instruction itself, and was there an objection of the instruction?
There are no objections there as well, Your Honor. So our argument is if you combine the errors, and I'm not discarding the first argument, but if you combine all the errors in this case, that there was so many errors that there was enough for a substantial risk of miscarriage of justice. If there's no further questions, I'll rest on my brief, or Mr. Katz's brief. Thank you.
Thank you very much. Seeing no further questions, we will now hear from the Commonwealth.
Good morning. May it please the court, Jessica Kenny on behalf of the Commonwealth. I'll address the first issue raised at this argument, and that is the prior conviction. So first, I just want to direct the court, and I'm sure you've reviewed it, but at page 66 in the second volume is where this initially is brought up, and it is raised by the defendant's own attorney on direct examination, and not just the fact of the prior conviction, but a lot of details surrounding that conviction. It was the defendant's attorney who asked who the plaintiff or the victim was, again, identifying it as the child victim's mother. Again, it was during this direct questioning that it was elicited that even though he pled guilty, or he was found guilty in March of 2016, that the actual events that caused the violation of the hearing was on Christmas Eve. During that exact time period where the defendant had just testified that they were so in love and they were young and they were happy and they were doing all these things together. It's a direct contradiction to exactly what he said. And so it was perfectly permissible for the Commonwealth then, once the defendant offered that evidence, to cross-examine and ask him questions about that. And I believe it was very strategic, the reason the trial counsel elicited details. From the very beginning of his case, his theory was, you're going to hear evidence that there was animosity in this family and that there might be a reason why the victim said the things he did. The whole theory of the defendant's case was it was a divided family and somebody somehow pressured or convinced or inadvertently got this child to make these allegations up that aren't true because of that animosity between the family. So the existence of the restraining order between mom and dad, the existence of the violation of the restraining order between mom and dad was helpful to the defendant to make that point, to say, see, this is a family divided. And he says it in his opening, and then again in his closing, he argued as well that that was the explanation for why he would say the things that he would say. It was, his terminology was, this was a family divided. On one side, you had mom, and on the other side, you have the defendant. And so it was
let's assume, excuse me, let's assume that we agree with you, that the Commonwealth or any party has the right to correct what they perceive to be an incorrect or misleading picture being painted on direct examination, and they can challenge it to some extent on cross-examination. What's the limiting principle on that? Because I think your brother's not disagreeing with what I just said. The argument is they went too far. They should have asked a couple of questions and moved on, and instead they got down in the mire into issues that really started to get tangential. So
And again,
where is the limiting principle? How far is too far?
so again, so the Commonwealth's cross-examination is at page 68. It's just literally 2 pages later. And so the first question that the prosecutor asks is, again, about that time period. How can you say that things were so wonderful if this is when it happened? And then it's the defendant's sort of non-responsive answers that lead us down this other path. So then the question is about that timeline, and then the defendant offers, well, she voluntarily dropped it. We worked everything out and everything was great. So it's a non-responsive answer about the time period and instead trying to justify the violation of the order. And so again, the question is re-asked. Is it before or after you violated the restraining orders and got convicted? Trying to narrow down that timeline that is at question here. She dropped it, and then I had to go to court about a month and a half later, and that's when they gave me the conviction for it. So now we have this answer that seems to imply somehow that the defendant didn't plead guilty to these offenses, and that he somehow is almost arguing his innocence for these offenses because he's alleging the court gave him a conviction. So the follow-up question is, well, they didn't give you a conviction. You pled guilty, correct? You admitted it, yes. And that you violated those restraining orders with her, correct? And then that's when the defendant, again, offers this sort of non-conforming answer, non-responsive. Yeah, I attempted to see my son for Christmas. That's why I got violated. Well, so again, so here's the defendant who's constantly answering these questions in a manner that he's trying to explain away the conviction. He's trying to distance himself from the culpability. And instead, he's giving more information about the underlying offense, but that's not the fault of the prosecutor that his answers are non-conforming. And again, there was no objection. So defense counsel could have objected and moved to strike the answer as non-responsive, and he didn't. Because again, I think it played to his hand in the way that his defense was, look, this was contentious between them, and mom might have a bias against dad, and that might be why their 4-year-old is saying that dad did these horrible things. And so it worked to his advantage in that respect, and there wasn't an objection, and even the judge didn't stop and instruct the witness to answer correctly. You open yourself up to it. It's a risk. Sometimes it works, sometimes it doesn't. But it did give, it wasn't all bad because it did give the defendant, fodder in his closing argument to say, look, there was this trouble here, and that's why the boy would be saying the things that he's saying, because it was between mom and dad and they had the bias, and it wasn't that these things actually happened.
At the same time, could it have bolstered his image with the jury, because the fact that it was Christmas Eve and the fact that he was willing to arguably bend the rules so that he could see his son on Christmas Eve?
Right. So of course there is a sympathetic aspect to it. This idea that this poor dad just wants to see his kid on Christmas Eve. He had just testified on direct that the day of his son's birth was the greatest day of his life and all these fun things they did together. And so of course there was an aspect of sympathy there. The Commonwealth obviously, again, through cross-examination, through closing argument, tried to show that, look, this isn't a sympathetic father. This is someone who's, in conjunction with the case law, willing to break the law. And so if you can't, trust what he's telling you about, the state of their relationship and the state of the restraining order and whether he was given a conviction or he pled guilty, then you can't trust when he says, I didn't sexually assault my son. But I definitely think that there was some, like I said, it was not all bad for the defendant because it did elicit some sympathetic things and some things they could use during their closing to argue that the boy was made to say this.
So what's the state of the record about when the restraining order was in effect and when it wasn't? Is there anything about that? Because that kind of came through a very messy on this.
So the defense attorney asked about the restraining order violation that he was convicted of in March of 2016. And then again, during direct, the defendant said it was Christmas Eve. And so I from the record, it appears that he violated in December of on Christmas Eve of 2015. and then pled guilty in March. And then again, because the Commonwealth had sought permission to introduce both those convictions, the prosecutor also asked about a conviction, I believe it was in January of 2016 as well. So it's unclear, again, because the prosecutor didn't ask any background or any factual information about that January 2016 conviction. But we at least know there was an alleged violation on Christmas Eve, and then there were 2 guilty pleas, one in March of 16 and one in January of 16. And then again, just to show that the prosecutor wasn't taking advantage of this, when she asked about the second one in January, no further questions were asked about the circumstances or the fact of that one. The Commonwealth can't do that. The defendant has a little more leeway to do that if it helps his defense. And so that's why presumably he did it. And that's why the judge permitted him to do it. And he didn't make any objections about it when the Commonwealth followed up. Again, with regard to the closing argument, I think that both sides utilized this information to their advantage. The defendant arguing, obviously, that this is the reason that there's the bias. The Commonwealth using the exact reason that you can use this for, to assess his credibility like you would any other witness. It's exactly what the judge would instruct in the instructions, and it's exactly what the case law says the permissible use for it is. And again, I disagree that this was a weak case. This was a strong case for the Commonwealth. We tell juries every day that it's not the number of witnesses or the volume of evidence that matters. And so it doesn't matter that there was one precipient witness being the victim and one first complaint witness in a relatively short trial. This now 6-year-old's testimony was incredibly compelling. He, that point of the trial where he's looking at that anatomic drawing of a little boy and he's asked to identify the part that his dad made him touch. And he just very candidly says, well, that's it, but my dad's is much bigger than that. I mean, that just screams of truth right there, because a 6 or a 4-year-old boy, wouldn't know the size of his father's penis if he hadn't been told or made to do the things that he was told and made to do. And so I disagree that it wasn't a strong case. This was a very compelling case, even though it rested on small amount of evidence. And so even if the court finds that there was some error somehow, or the defendant shouldn't have been allowed to go on in his non-responsive answers, and when you're looking at a substantial risk of miscarriage of justice here, I just, given the strength of the other evidence, I don't think that that can be shown.
So counsel, what about the defendant's argument on the prior bad acts, where the prosecutor basically says the law does not matter to the defendant? Is that crossing the line into propensity?
Well, no, because again, there's a case directly in my brief, and the willingness to violate the law translates to willingness to give false testimony, and it is solely for that purpose that evidence of a prior conviction is received. And so that's important. Again, the jury was left to reconcile a defendant who's testifying, I never touched my son, but also I was in a loving, wonderful relationship with his mother at the time that I was violating and being convicted of restraining orders. I think, the jury needs to reconcile, potentially 2 different truths. And ultimately what the defendant was testifying to, the reason presumably he testified, was to deny that he did the things that his son said he did. So the only way to assess his credibility is to use things like this, again, inconsistent statements, or in this case, the exact permitted purpose of prior convictions. And that is willingness to violate the law, is willingness to give false testimony. And that's permissible, and the reason that they are introduced with that information. So I don't think that it went beyond that, especially given the defendant's non-responsive answers like that. To me, it was worth it to see my son. I knew about the restraining order. Again, to Judge Desmond's point, also very compelling and sympathetic as well. It could have worked in his advantage. A loving father who just felt that he was being wrongly kept from his son on Christmas Eve. Also, from the prosecutor's standpoint, someone who doesn't respect the law and arguably doesn't respect the oath he took to tell the truth.
So the defense counsel argues that when the judge gave the instruction, he said this is hearsay, but there's this exception. And in the same 2 pages, he then got around to the correct instruction, and defense counsel says, well, we don't know which one the jury used. What do you say to that?
So I guess, and I dropped a footnote about the language on page 35 of my brief, the language that the judge should have used as opposed to the first complaint is a rule against hearsay. I think for this to really matter to the jury, we have to assume that the jury knows the legal definition of hearsay. Because the judge never actually said that you can use this for the truth of the matter, which is the way we define hearsay. And in fact, the judge correctly said, you cannot use this to consider, you may not consider the first complaint testimony as evidence that the alleged assault in fact occurred. So, I mean, technically, is it a slip of the tongue or a slip of the, the explanation there? Perhaps, like, word for word, but you have to assume that the jury would understand this legal concept of hearsay, which, isn't defined to them otherwise, I don't believe. And you have the judge, even if that was an error, specifically telling them this is the permitted purpose and this is the impermissible purpose. You cannot ever use this as proof that it happened. So the judge gives them the correct information about how they can use it. And it's more just kind of when he's talking about the origins of this exception in our law that he uses the expression hearsay, which I suggest is not a term legally that the jurors would understand what that means the way that, that lawyers might. So I don't think that that is problematic. And again, the last instruction they got at the end, it was completely perfect. There was no issue raised. And again, made that same conclusion as to this is the permissible purpose and this is the impermissible purpose. And so I don't think there was any confusion with the jury. Seeing no further questions.
Are there any further questions from the panel? And seeing none, I say thank you to both counsel for your excellent briefs and you're very helpful.
All right, I'll let you know when it's being recorded. The case is now being recorded.
Welcome back to the December 15th, 2020 sitting of the Massachusetts Appeals Court. I'm Eric Nyman, sitting today with Justice Vicki Henry and Justice Kenneth Desmond. We'll call the next case on the list. It is docket 2019 P1728, Commonwealth v. Studiner. We'll hear first from counsel for the appellant, Attorney DeMello.
Thank you, Your Honor. In this case, Mr. Studiner was unjustly convicted of multiple counts of receiving stolen property that the Commonwealth was never able to prove were actually stolen. Furthermore, there was insufficient evidence beyond reasonable doubt that Mr. Studiner actually knew any of these items were stolen. We know from the case law, receiving stolen property requires proof that both the items were stolen and that the defendant subjectively believed that the items were stolen. Here, you've got evidence that the PlayStation and the Kodak camera, counts 2 and 3, there's no evidence here that these items were reported stolen by anyone. There's no serial number or unique mark like in the Boudreaux case, distinguished from count 1, the laptop, where it was actually identified by a serial number and someone actually reported it stolen. These two items, no one's reported these things stolen, and there's no serial number to identify them. There's no witness that came forward to identify them. And the only evidence that the Commonwealth seems to present is that because this individual, Mr. Avery, sold these items to the defendant, that they must have been stolen. But
Attorney
there's no
DeMello,
evidence in the record.
let me ask you this question. Assume, and I know you can test this, but assume that we agree under the Lattimore standard that the defendant's written statement constitutes an admission. I want you to make that assumption. There's reference in it not only to the Toshiba, which was an identified stolen item, but also to the PS3, which I believe is a PlayStation 3. And one of the two items that you're contesting on this basis is the PlayStation. Why does that not get the Commonwealth over the hurdle with regard to that item?
Well, I think the problems with that specifically are in the statement itself. I mean, if you look at the statement, it says items that were identified as stolen. He's not admitting there that these are stolen items. He's saying,
well, I asked you for purposes of the question to assume that under the Lattimore standard, we think under the totality of circumstances that does constitute an admission.
If it
If
does,
that's the case, then would you agree that there is enough under the Lattimore to satisfy the Lattimore standard with respect to the PlayStation as well?
if that's the case, given that assumption, I think I'd have to agree that under the Lattimore standard, that would be enough. Again, I would challenge that representation.
In the record should clearly reflect that that is a large part of your brief. So again, that is a hypothetical for right now.
Right. In any case,
To follow up, so the fact that the Toshiba, the laptop was reported stolen, or that the serial number was reported to the police, none of those bear on the defendant's state of mind, right?
I would agree with that.
Right. But the response, I think, from the Commonwealth would be, given the quantity of things that this one person provided to the defendant, that and the fact that he didn't log it and seemingly didn't have at least some receipts. He wouldn't have receipts for these things he hadn't sold yet, right? Like because you wouldn't provide a receipt, or would he have, or is the reference to receipts to giving them to Avery?
I believe that there was a question about whether or not he had receipts, copies of receipts that he gave to Avery.
Okay. So but the Commonwealth's point is basically where Avery repeatedly stole him a really quite a high volume of electronics over a short period of time, and he failed to log the transactions as required by Commonwealth law, and failed to produce any receipts, that was sufficient to prove his subjective knowledge. So what's your response to that?
The defendant's position would be that given the totality of the circumstances, that wouldn't be sufficient. And one of the things to consider is that this is a pawn shop. People bring things into a pawn shop to sell them regularly. And also the defendant did testify, look, I became suspicious. I asked him, hey, where is all this stuff coming from? And he said he was a handyman and he got this stuff in barter. And with respect to, you look at some of the case law and it says some people are more suspicious than other people, and you can't hold it against someone because they're not suspicious as someone else might be.
Was the jury free to reject that testimony? I mean, Commonwealth v. Frangillo says that you don't check your common sense, and you're allowed to call on that with respect to the totality of the circumstances and the evidence. And so just because he said, well, he told me he was a handyman and I just accepted that at face value, was the jury free to reject that?
The jury was free to reject that, as they're free to reject any testimony. But again, the defendant's position would be, if you look at the totality of the circumstances here, this is a beyond reasonable doubt standard. This was insufficient beyond reasonable doubt to prove his subjective knowledge.
I understand, but here's a gentleman who repeatedly brought in these electronics of reasonable value. And we know that at least one of the three items that he brought in that morning was indeed stolen. And so why is that not a reasonable inference?
Well, just because one item was brought in and was stolen doesn't necessarily mean that all of the items were stolen.
Not necessarily.
We don't have any information as to where Mr. Avery got these. Who knows? Maybe he bought them from someone else and sold them. We don't know. That information is not in the record.
So doesn't that go to the weight of the evidence?
It goes to the weight of the evidence precisely. And the defendant's position is that the weight here is such that no rational jury could find beyond reasonable doubt that these facts constituted sufficient proof beyond reasonable doubt that Mr. Studner knew these items were stolen.
How about the information that Justice Desmond just presented in combination with the fact that the defendant, I think, sold 9 phones Mr. Avery sold 9 phones or iPhones to the defendant in the first month, among other items, when they started doing business, and combined with the fact that all of a sudden the defendant stopped logging or entering things into the logbook when it pertained to Mr. Avery. Viewed in combination, can't much more be inferred from that kind of conduct?
Well, I would argue with respect to the logging of the items, it's not as if Mr. Studner didn't log anything from Mr. Avery. There are
He did up until a certain point in time.
Right, and he's
And then
bringing
it
in a
suddenly
number of
stopped.
items that are logged. So, I mean, he provides the explanation that, hey, he's not a great bookkeeper. And you can't hold it against him that he's not a great bookkeeper. I understand that there is evidence here. Again, the defendant's position is it's insufficient beyond reasonable doubt in this case to prove that he knew these items were stolen, especially when you've got items that the police never really identified as stolen.
Can we move on to the camera, the Kodak camera?
Sure.
What do you say is the evidence in the light most favorable to the Commonwealth regarding the Kodak camera? And I'm speaking to both elements that you're challenging here.
Well, first of all, I don't think there's any evidence in the record that the Kodak camera was actually stolen. There was an indication of a different make of camera that was on the list of items they were looking for in the search warrant, but the Kodak camera wasn't listed. It was a different type of camera. So there's actually no evidence that this camera was stolen. And then with respect to knowledge, it's the same arguments that we've been throwing about. The defendant's position is there's insufficient evidence here with the circumstantial evidence the Commonwealth presented that Mr. Studner knew these items were stolen beyond reasonable doubt.
My question is a little different, and that is, what evidence was there with respect to the Kodak camera? I mean, unlike the other items, it wasn't mentioned in the written statement. I believe there's no information that it was found at the store. What information is there regarding the Kodak camera having been bought by your client or received by your client?
Well, I believe the Kodak camera was one of the items that Mr. Studner told police, hey, Mr. Avery brought these items in. One of them was the Kodak camera. And I don't think there was any evidence. I mean, correct me if I'm wrong, but I don't think there was any evidence in the record that Kodak camera was ever reported as stolen. I don't think there's any evidence. I guess the only evidence would be the admission that we were talking about, where he says items identified as stolen.
But the Kodak camera wasn't referenced in that written admission, correct? Or that written statement, I should say.
I think you're correct about that. Again, I'm not sure where the jury came up with this particular, the evidence to convict on this particular item. I don't think it's in the record. If there are no further questions on that issue, I'd like to move on to the Miranda issue. Defendant's position is that the trial court erred when it found that Mr. Studner's statement was not obtained in violation of his Miranda rights. The factual findings by the judge, it's undisputed that there were no Miranda warnings here before this statement was obtained. And while the encounter may not have started as custodial when they first executed the search warrant, defendant's position is that it became custodial after police escalated their questioning and created a fundamental change in the atmosphere.
At what stage do you point to where you say that he was not free to leave?
Well, one thing I would point out is that the issue of whether or not he's free to leave is a question of what the defendant subjectively reasonably believes. And what I would point out is that, there's much made of this, he's allowed to go and smoke a cigarette. But if you look at the transcript on page 13 of the motion transcript, he asks if he can go out and smoke a cigarette. So I'd argue that that's evidence that he doesn't believe he's free to leave from the get-go. I think that's one of the elements that's stronger for the defendant, frankly, that he felt, 5 officers are present. I think there are elements of custodial interrogation from the start are here. One of them is the 5 officers. Another one is the fact that, he's asking to smoke a cigarette. He's not feeling like he's free to leave.
Right, but I'm sorry to interrupt you, but you said that this did not start as a custodial interrogation, but became one. And I think Justice Desmond's question is, when? At what point do you say this became custodial?
I think it happened over time, but I believe it was actually just before they asked for the statement. So you've got these elements in the beginning, and then the questions escalate. They asked him about these televisions that they noticed a few days before that were now missing. Well, where are the receipts for those televisions? I don't have them. Well, what about all this stuff that's missing from the logbook? Oh, I'm just a bad record keeper. Well, now you're getting to the point where he's admitting effectively crimes. But it doesn't just end there. He gets a phone call from Mr. Avery. Again, he doesn't feel like he's free to just take that call and walk away. He says, hey, tells police, Avery's calling. What do I do? He's basically asking for permission to answer the phone. And then he goes outside to depending on whose story you believe, meet Mr. Avery or smoke a cigarette. And then when he comes back in, the police ask to see his phone because Mr. Avery didn't show up. And so they're checking his phone to verify his story. I would argue that by that point, the atmosphere has fundamentally changed. And what you have is maybe the police are frustrated that Avery doesn't show up, and they say, okay, fine, now you've got to give us a statement. They sit him down and they ask him for a statement.
Do you agree? Do you agree that he was allowed to, without supervision, take the phone outside with him?
He was, Your Honor.
And nobody supervised whether he was making calls or receiving calls, and he didn't ask permission to take the phone, did he?
Well, I would take issue with that latter point. There's some testimony as to where the officers were and whether or not they could see him when he was outside. And again, I would point to the fact that it's Mr. Studner's subjective belief. Whether he reasonably believes he's free to leave.
I understand.
And I think given the totality here, he's not free to leave. He doesn't feel like he's free to leave.
Now, this is a gentleman who the police had come in and spoke to him, I think, on 20 previous occasions about similar stuff, his logbook, the property that he's receiving. Is that correct?
That's correct.
And it seems that he had a cordial relationship with the Worcester officer anyhow. Would you agree with that?
A cooperative one. I'm not sure cordial, but I would agree that it's at a minimum he's cooperative.
And that's what was happening on this particular day as well.
Well, I think there's a very different tenor on this particular occasion. First of all, they're executing a search warrant. That's not what happened on the 20 prior occasions. Mm-hmm. Second of all, they come with 5 officers. They are, there's all this stuff about him asking to smoke a cigarette, the phone call, sitting him down and getting a statement from him. I mean, they've certainly no evidence in the record that they've ever done something like that before. So I think the tenor of this particular meeting is very different from at least what's in the record about 20 prior occasions when police come in and they read what's in the logbook. And if you look at the defendant's testimony about that, he says, yeah, they'd come in, they'd look at the logbook and they'd say, hey, this guy that's in your logbook, he's suspected of X, Y, or Z. That's very different than coming in there the way they did on this particular occasion.
Your time's running short, but I have 2 quick questions. The first one, I just want to confirm you're challenging the failure to provide Miranda statements and the denial of the pretrial motion to suppress. Are you also challenging voluntariness of the statement? In other words, humane practice at trial?
I'm not raising that on appeal, Your Honor. I don't think the evidence raises to the level of that issue.
Okay. And my final question is the groom factors. Those factors for determining custody are fact specific. So do you have the burden in that context of finding the judges, of demonstrating that the judge's findings were clearly erroneous?
Well,
or is it a mixed question of fact and law?
I think it's a mixed question of fact and law. I think the judge makes factual findings, and in my brief, I cite those factual findings. And I think if you look at the judge's factual findings alone, the legal conclusion he draws from those factual findings is not the correct one. And that from his factual findings, well, I would also add the caveat that there are some things that the judge, I think, leaves out. But his factual findings plus the things he leaves out, I think it's clear that he came to the wrong decision on this particular one.
So in other words, you're not saying that his findings are clearly erroneous. You said your argument is he omitted some relevant material and that led to an error of law in his ultimate judgment.
Well, not just that he omitted some material. I think that the omissions are fairly minor, but I think I point them out in my brief. But I think even if you look at the factual findings that he made, just based on his factual findings, I think he reached the wrong conclusion. And then you add some of the little items that he omitted, and I think it's an even bigger problem.
That's helpful. Justice Henry, Justice Desmond, any further questions for Mr. Attorney DeMello? No. Thank you, sir. We will now hear from Attorney Kittredge.
Judge, for the Commonwealth, Joseph Kittredge. I would suggest, Judge, that in the light most favorable to the Commonwealth, more than enough evidence was introduced to satisfy a rational trier of fact as to the elements of receiving stolen property. I would suggest, Judge, that the Commonwealth introduced the testimony of Colleen Florio, who indicated that her Toshiba laptop had been stolen in a housebreak 8 days prior to the execution of this search warrant. I would suggest that she indicated that that computer contained 7 years of photos, documents, paperwork, children's records relative to her family, that when she ultimately received the computer back after it had been stolen from police, when she received it back from police, everything on the computer had been wiped out. Everything was gone. All her information was taken. It also was 8 days prior to the execution of the warrant. I would suggest, obviously, a recently stolen item in the defendant's possession.
What is the evidence with respect to the Kodak camera?
Well, Judge,
that one, it was actually stolen, and that two, the defendant knew that that item was stolen. Can you tell us with particularity, where in the record can we find that evidence?
Well, Judge, that evidence is in the statement and ultimately the written statement and the oral statements of Mr. Schuldner.
Let me stop you right there. Am I correct that there is nothing in the written statement referencing a Kodak camera?
That's correct. He does not refer to the Kodak camera in his written statement. He does not identify that in the statement.
How does the written statement, let me just start there. How does the written statement help you in responding to my questions with regard to the Kodak camera alone?
Well, Judge, I would say that he's in his written statement, he's referring to 5 items that were brought to his store that morning by Mr. Avery. One of those items is the camera. And I would suggest—
How do we know that?
I believe it is indicated, Judge. I believe perhaps in Detective Cadron's testimony, but I believe, Judge, that certainly the defendant indicates that that is one of the items he receives out of the 5 that morning. That is one of the 5 items that are ultimately taken in by the police. And I think ultimately, Judge, identified—
Well, the statement lists the Toshiba TV, the Toshiba laptop, the PS3, quote, just to name a few, close quote.
Yes, he doesn't, just to name a few. He doesn't, obviously, it's not an exhaustive list where he's naming every item that he received that morning. So I would suggest, Judge, that one of the other items is that camera. And that is one of the other items that he received that morning from Mr. Avery.
We can find that in the record in testimony from Detective Cadron, is what you're telling us?
I believe it is from Detective Cadron, Judge, yes.
So in other words, in the record, she testified that among the items that Avery brought in on that very morning was the Kodak camera, correct?
I think it was more likely that her testimony was that the Kodak camera was one of the items that she took from Avery, from the defendant, Mr. Schuldner, that morning.
Did she testify that Avery said that they were identified, that it was stolen, or just that Avery brought it in that morning?
Just that Avery brought it in that morning, that he had purchased these 5 items from Mr. Avery that very morning.
So I'm sorry, go ahead.
It's 11 o'clock in the morning, 11:30 when the police are there. Mr. Avery has already stopped by and made this transaction.
So in other words, you're asking us to sort of combine the defendant's written statement indicating that certain stolen items were brought in by Avery, and with Detective Cadron's testimony that morning he brought in the Kodak camera as well.
Yes, that was one of the items that was received by Mr. Schuldner from Mr. Avery.
Is there any other evidence with respect to the Kodak camera to satisfy both of the elements that I mentioned earlier? Or is that the sum and substance with respect to the Kodak camera?
Well, I would suggest that as to the particularity of the Kodak camera being mentioned, I would say yes, that is the extent of it. I would
And then we
say,
have the combination of other factors being the logbook and the consciousness.
I would say all the other evidence is more than adequate to indicate that he certainly knew that these items were stolen.
So then here's my last question with respect to the Kodak camera. Well, I shouldn't promise that, but ideally this will be my last question with respect to the Kodak camera. Based on the facts as I just laid them out, or the circumstances, what is your best case, SJC or appeals court published case for the proposition that the evidence is sufficient to establish the knowledge element at issue here?
Well, Judge, I think that all the case law regarding the stolen property generally talk about the fact that you have to look at all of the circumstances regarding the interactions between the players. And I would suggest that when you do that, it's clear that I'm sorry, Judge, I lost my train of thought. Could you repeat the question?
My question was so poorly phrased, no, I couldn't repeat it. So let me try again.
Thank you.
With respect to the Kodak camera, what is the best case you have for the proposition that the evidence here satisfies, one, the element of proof that the Kodak camera was actually stolen, and two, the element that the defendant knew that that item was stolen?
I would say, Judge, that the evidence is that the defendant knew that all of the Commonwealth's evidence established that the defendant knew that all of the items he was receiving from Mr. Avery was stolen. And I would suggest that the Kodak camera being one of those items, he certainly understood that it was stolen.
So in other words, you don't have any sort of case that, I understand it's a totality.
No, I don't have a particular
parallel
case
factual case of any kind that gives us guidance.
that suggests, right, that's factually on point or close to it.
So on page, I'm sorry to interrupt you.
I'm sorry.
On
Yes,
page
Judge.
19 of your brief, you say the defendant told the detectives that he had purchased items from Avery earlier that morning. He then showed the detectives the 5 items that he had purchased from Avery. Those five items were the Samsung television, a PlayStation joystick, a Kodak camera, and a Sony controller, and the Toshiba flat screen television. Is that the testimony that you're relying on?
Yes, it is, Your Honor.
And that's supposed to be transcript 399 to 10, transcript 3 122 or 99 to 102.
Yes, Judge. I believe those are the correct numbers. And I would suggest, Judge, that the evidence that the Commonwealth introduced was more than sufficient. I would suggest that.
Let's focus on the statement for a minute, because I think the average high school English teacher would say that this statement does not, in fact, say that Mr. Avery thought these items were stolen because of the use of passive voice. Right? It says, today, Millbury and Sutton PD came in asking about stolen items, period. Items identified as stolen were brought in by Brian Avery, and then he lists the items. Where does this say that this fellow knew that the items were stolen?
I would suggest, Judge, it's apparent from his writing, because he's the only one out of those individuals who has any knowledge as to where those items came from. The police show up, they don't know that those items have been brought there this morning. They have no idea that those items are there. They're looking for a list of items and not these new items that were brought there that morning. They go in, they ask Mr. Schudener about those items. He then identifies the 5 items. And I would suggest, Judge, that he indicates that those items were brought in that morning. And I would suggest that he's the only one with the knowledge to identify them as stolen. There's no police reports that the police are in possession of that suggest these items are stolen. They don't know that those items are there. When they go there, they have no idea those items are there. They ask him about they find the laptop from Miss Florio, and the defendant immediately says, they ask him, is this in the logbook? Oh, no, it's not in the logbook, but I know who I got that from. I bought so much stuff from him that I stopped putting his name in the book, Brian Avery. So I would suggest, Judge, that is the evidence. And I would suggest that the fact that the laptop is not in the logbook, I would suggest none of the items ultimately are in the logbook. And I would suggest also, Judge, that as far as he's the only individual with the knowledge to say those items were stolen. The police were not suggesting those items were stolen until the defendant brought him up and indicated he had purchased them that day from Mr. Avery. And I think at that point,
Well, why is she doing anything more than saying I bought them from Mr. Avery today?
I'm sorry, Judge.
Why is this statement indicating anything more than that the defendant bought those items from Mr. Avery that day?
I'm not saying it does indicate more than that, Judge, but it does indicate that he purchased those 5 items from him that day. And I would suggest that the evidence that the Commonwealth introduced throughout the course of the case was clear that he knew that all the items he was purchasing from Brian Avery were not Mr. Avery's items, that he had stole these items. And I would suggest, Judge, that the fact that the defendant wrote the statement the way he did, he's still the only one who can say they were stolen. He in fact said they were stolen. And I would suggest, Judge, that certainly pursuant to Lattimore, that's enough evidence. And I would suggest that it shows that those 5 items are acknowledged by this defendant to have been stolen. And I would suggest, Judge, that he writes that because he knows that. And I would suggest at that point, as I indicated throughout, he's trying to make himself a Commonwealth witness. So his attempt at that point is to try to make himself a Commonwealth witness. And I think he does everything that he can to try to do that. In fact, when Mr. Avery calls later, there's no indication that the police had any understanding that Mr. Avery was on the phone. He could have hung the phone up. He could have shut it off. He could have done a million things. Instead, he answers the call and he says to the police, "It's Brian Avery. What do you want me to do?" And I suggest, Judge, he did everything he could to try to make this happen because he understood his situation and he wanted to be a witness, not a defendant. And I would suggest, Judge, that as indicated previously at the motion hearing, the defendant indicated that he had was going to be a witness in a number of cases for the Commonwealth. He certainly played that game and certainly was aware of that game. And I suggest, Judge, that's what he's doing here. And that's what the Commonwealth argued at trial.
Counsel, if the defendant was in fact the most gullible person in the world and he believed Mr. Avery that he was getting this information in trade, I mean, let's assume he was the Rose Nyland of the Golden Girls naive. Can he be guilty of receiving stolen property?
If subjectively he never believes the property is stolen, I would suggest he would have a good defense. So, but I would suggest that's not what he is. That's not what this defendant is. And I would suggest, Judge, looking at his testimony in the motion hearing as well as at trial, and this defendant was not Miss Rose Nyland. I would say that, Judge. I'd stipulate to that, frankly. But I would suggest that he was somebody who knew the deal, knew what he was doing, and attempted to manipulate the circumstances to suit him. And that's why he attempted to drag Mr. Avery back to his store. He was the one who was doing that, not the police. He was the manipulator. He was the orchestrator. He was the actor. That's why his statement ultimately is a statement that he's going to make. No one's going to stop him from making that statement. He's going to talk his way out of it. And I would suggest that's what he's doing. He's trying to talk his way out of his circumstance. And I would suggest that as he was digging the hole, he was digging the hole for himself as well as for Mr. Avery. And I would suggest, Judge, that that's what the Commonwealth argued, and I would suggest that's what the jury found. And as far as the logbook that was introduced, that showed that I believe the defendant had purchased 13 cell phones from Mr. Avery in maybe 5 weeks. And I would suggest, Judge, you can only draw one inference from 13 cell phones in 5 weeks. And I would suggest that that was the inference the Commonwealth was asking the jury to draw. And I would suggest that they properly drew it. And
Mr. Kittredge, go ahead, Judge Desmond, please.
I just had one other question. You tell us in your brief that the detectives had walked by the store a couple days prior and had observed what they believed to be a couple of stolen items in the window. Is that correct?
Yes, Judge. 2 days before the execution of the warrant, they walked by the store. They saw 2 items, 2 televisions that were consistent with what had been listed as stolen in police reports that they had. They observed those 2 items. They went back, I believe it was a day or 2 days later, to execute the warrant. They asked the defendant about those 2 items, and he indicated that he had sold both of them, but neither transaction was in the logbook. He had no receipts. He couldn't say what he sold them for. He couldn't say who he sold them to. And I would suggest, Judge, it's another example of how he ran his business. He had no interest in recording this information because he knew that it would ultimately lead to great difficulty in criminal court. And I would suggest this was just another example of him not recording these items. And I would suggest it shows that this wasn't just a situation with this one defendant, with this one buyer.
Mr. Kittredge, I'm sorry, I have to interrupt you because you're out of time, but I have one final question, and that is,
So do I.
we have at least 2 questions left for you. So the first question is with respect to the 5 items that the defendant mentioned to the police officer that morning, which includes the camera. Is there any evidence in the record, apart from the written statement, that the defendant told the police officers that those items were stolen?
He didn't say that they were stolen. He said that he had purchased them from Brian Avery. So I would suggest.
But he says he purchased them from Avery. And then in his written statement, he referred to them as items identified as stolen.
Correct. And I would suggest he's the one identifying them as stolen. When he purchases them, he knows they're stolen. And that's why he identifies them that way.
Is there any indication in the record that the police officers identified those items to him as being stolen?
No, the police officers didn't even know that those items existed or had them
that morning, and he pointed them out.
And I would suggest, Judge, that Mr. Avery thought, Mr. Schuldner thought that perhaps the police were there looking for these 5 items, and he was quick to say, he brought me these 5 today. Here they are. And he showed him those 5 items. I would suggest because from his perspective, that could be what they were looking for.
I understand your argument. Now, Justice Henry has a question for you.
Yeah, why was it relevant and admissible for the detective to testify that the defendant's secondhand license had been revoked? All the brief says is that it presents the full picture, but there's many instances where we have evidentiary rules that would limit this kind of testimony.
I would suggest, Judge, when I asked the question, I was the trial counsel. When I asked the question, it wasn't about his the status of his license. It was whether or not his store had closed because that mall had closed. So I wasn't asking relative to that. And I would suggest, Judge, if you look at Detective Gingerelli's statement, he says he believes that his license was revoked. And he believes that it occurred after the execution of the search warrant. And he believes that the defendant's store closed as a result of the revocation. But I would suggest he indicates that's his belief. There were no further questions on it by the Commonwealth. There were no questions on the issue by the defendant. There was no argument in closings by either party relative to that. And I would
actually, didn't the defendant testify that his license was not revoked?
Yes, he did. The defendant testified that, in fact, his license was not revoked and that he had his license until the store closed. That's what he indicated. I asked no questions about that, Judge. I believed it to be an extraneous issue. I didn't want to create a situation where that became a focal point. And I thought it was.
I'm going to have to stop you there. Justice Henry, any further questions? Justice Desmond?
Thank you.
No, I'd like to thank both counsel for their excellent.
No, Judge, thank you.
Okay. Then Matt, I think we're ready to go live.
All right, I'll let you know when the case is being live streamed. The case is now being recorded.
Good morning. Again, this is the December 15th, 2020 sitting of the Massachusetts Appeals Court. We will call the 3rd case on the list, 2020-P0094, McDonough versus Leone. We will hear first from counsel for the appellant.
Good morning, and may it please the court. Jonas Jacobson here for Kevin and Emer McDonough as trustees of the 30 to 32 Whitman Ave Realty Trust. As the court is aware, this is a case that comes to the appeals court on a reconstructed record. So I've had the opportunity to see Mr. Rafel in action in front of the trial court below. Obviously, there was no lawyer there for the trial, and I can say that he's an excellent advocate, and I'm not surprised that he totally destroyed the McDonoughs at trial. Dominant performance. He's an experienced lawyer with many years experience practicing. My client is a roofer, and I think it's interesting to consider what it would mean to pro se roof for the members of this panel, and consider that given the size of the judgment in this case, if I were to have fallen off my roof, depending upon which level of my house, I might incur damages that amounted to less money than the damages in this case. I think it's easy, because we do it every day, to ignore how important our job is to the people that we represent and how serious the consequences of not having a lawyer can be. So
counsel, I was going to ask this at the end, but since you put it right out here at the beginning, the judge only awarded $10,000 in pain and suffering. The rest of the damages were all related to medical expenses and lost wages. So if we reverse, do you agree that that judgment from a subsequent trial could be higher?
It's possible.
Substantially higher. I mean, 10,000 pain and suffering for a rotator cuff surgery and months of PT. Your clients, if you prevail right now, your clients could be in a far worse situation. Do you agree with that?
It's possible. The case will be retried. I think the distinction is that a lawyer below would know to argue comparative negligence. And I think that there's a case for that here, a significant case. So even if the pain and suffering damages were, to double or even triple, if the entirety of the ward were cut down by 30-40%, I think that would ultimately result in a lower judgment. I think
some people use the rule of thumb of that the pain and suffering could be up to 3 times the medicals and the lost wages. So we're talking 300,000 in pain and suffering, even if that's chopped down for some negligence on the tenant's part. You still could be far worse off.
I can appreciate the that possibility for sure, and the McDonoughs are committed to trial counsel, who would have represented them, had they been given the opportunity to proceed with counsel. And I have every faith in that lawyer, and I'm sure that he'll do his best on their behalf.
So on this issue about a jury trial, do the rules have a bit of a donut hole for cases where the tenant asserts a non-compulsory counterclaim against the landlord on the day the answer is due?
I think that's well said. The rules do create a hole where a case like this, big money personal injury case, is a facts case. It's not really a law case, and it ought to be tried by a finder of fact with a dozen pairs of eyes. And if this court were to say in this case, listen, we think a jury trial is probably appropriate in these kinds of cases. Where there is, for example, a non-compulsory counterclaim, I think that would provide helpful guidance to the housing courts and to the trial courts below. There really is a dearth of case law interpreting 39B.
But to respond to that, though, doesn't our case law as it exists essentially say if you don't assert that jury trial in the first instance or before the responsive pleading comes in, you're proceeding at your own risk, because there could be counterclaims and you don't know what they're going to be. So you need to know that going in. And it's always safer to ask for a jury trial when you file your complaint, right?
Well, except in summary process where time is of the essence. So I think I appreciate that question a lot, because I think it goes exactly to the heart of Justice Henry's question, which is, listen, we're gonna be potentially dealing with a big money counterclaim where the landlord might say, I think this tenant needs to be in front of a jury, but because the rent wasn't being paid or whatever it is, they don't have the opportunity to assert that in the first instance. And practical effect, it takes, a while to get to a jury trial in the housing court.
That I understand, but is it unusual to see counterclaims in summary process cases?
Is it unusual? I think it's not unusual to see a certain class of counterclaims that might have the effect of providing the tenant with some negotiation leverage down with the mediators. But is it unusual to have a high value personal injury case tried as a counterclaim? I think, yeah, that's pretty unusual. Ordinarily, there would be insurance. In this case, you may recall my client's insurance agent stole their premiums.
Would you agree that most litigants in the housing court are self-represented?
Yes, I think that's true. And I think that that's what Jartney says too. So I think that I'm bound by not only my own observations, but by the case law.
So why was the tenant's motion for a jury trial denied back in June of 2015, which seems to be at a time that the landlords had also asked for a jury trial?
I don't know. I would guess that the court denied it because it is administratively difficult to get a trial in the housing court. And I think that there are probably internal judicial standards that I kind of have an opaque, comprehension of, that encourage the judges to keep the cases moving. I mean, the housing court tries hundreds of cases, in the summary process session. So, jury trials do slow things up. The question is where you have here this unusual circumstance of a really high dollar. I mean, the judge gave a $100,000 attachment, personal injury case. Probably that should have been tried to a jury in the judge's discretion, of course.
So
Go ahead, please.
You argue that a prepared lawyer would have had the daughter, Molly, in the courtroom, and the tenants respond in their brief that, there was an attorney for the landlords in court that day, and he did not have Molly there. So what do you say to that?
I think that he believed he was going to be able to withdraw, and he did withdraw. I think if the judge had not let him withdraw and Molly had not testified, also the trial went 2 days, Molly could have come in a second day as a rebuttal witness or something like that. But I think then the McDonoughs could have said, listen, you should have put our daughter on, and you didn't do that. And that would have given them grounds for some claim potentially against Mr. O'Malley. But I think, it did go a second day. So,
The McDonoughs weren't surprised that counsel was moving to withdraw on the day of trial, were they?
I think they were actually surprised that he was moving to withdraw. I'm not sure that that's in the record, but I believe that they were surprised.
Well, hadn't he alerted them a couple of days before the trial date that he was going to be moving to withdraw?
I'm sorry, I don't have the answer to your question offhand. I'm not sure that it's in the record, but my understanding is that it was pretty shocking to my clients. Even if he did alert them, the record reflects that he faxed his motion to withdraw 2 days beforehand, which is kind of not enough time to find a lawyer willing to try any kind of case. I mean, hard to jump in 2 days before and put yourself on the line like that.
So go ahead, Judge Desmond, finish.
That's all right. I was just going to ask one other question. Was the reason that this lawyer was withdrawing was for the same reason that the previous lawyer withdrew? Is that right?
So that's what he put in his affidavit, but the record reflects that the McDonoughs were handed a folder, which was just stuffed with paper, and they don't believe that he was prepared for trial at all, and that the reason that he was withdrawing was because he hadn't prepared the case and didn't want to lose it.
Is any of that in the record or in the affidavit that they submitted?
That is not in the record, no.
Right. I thought the record reflected that he withdrew because he hadn't been paid, correct?
That's what he said, yeah.
And the prior lawyer withdrew because he or she hadn't been paid, correct?
That's what the record reflects, yep.
And weren't there two other lawyers that they had retained prior to that?
Not exactly. The McDonoughs had their insurance agent stole their premiums. So he had hired lawyers and he said, I will pay for the lawyer. And then he never paid for the lawyer. So they were under the belief that he was going to make good his mistake. He didn't do that. And then those lawyers, when he never paid, withdrew. And he's like, no, I'll definitely pay the next one. And then they had, I think, a lawyer for the day at one point. So they really only had the two lawyers.
What makes
And
this,
I'm sorry.
I'm just going to say, what makes this a more difficult case, if this is the situation where someone's lawyer withdrew on the day of trial, a very strong case, in my view anyway, for possible abuse of discretion. When there is a pattern of not paying your attorney and having your attorneys withdraw because of that reason, and there have been multiple continuances, and lo and behold, once again, on the eve of trial, you still haven't paid your attorney, doesn't that make it a more difficult argument that the judge, that there was an abuse of discretion by the trial judge?
No, because my fourth argument is that the judge erred in allowing him to withdraw. So even if the judge was going to say, no, we're not going to grant you a continuance in this case, the judge should then have refused to let Mr. O'Malley out of the case. He could have, filed the claim for his fees against the McDonoughs, and he, until he withdrew, was still obligated to prepare. He was representing them up until the time that his withdrawal was allowed.
And you would expect trial counsel to be required to try a case without being paid for doing so?
Yes, I think that trial counsel should have either withdrawn earlier and given them the opportunity to find a new lawyer at that point, or I think that the judge should have said, I'm sorry, but you can't have a continuance at this late date, Mr. O'Malley, because we're going to trial now. They're expecting you to be here. I can't allow this and then refuse them a continuance. That would have also been an acceptable choice.
How can they reasonably have expected their lawyer to be there when they hadn't paid their lawyer?
I want to make sure we're clear about this, though. I'm not sure the record actually says that. And if it does, I'd like to hear you tell us, because his affidavit, which is at the record, page 40, says there's been a breakdown in the relationship. It does not say that he hasn't been paid.
That's correct. So he said in his affidavit at one point that there's an ethical issue of some kind, and then in another section he suggests that I think he produced something to Mr. Rafel. I'm not sure why he did that, saying that he hadn't been paid.
Where is that in the record?
I can send a 16L letter and point that out to you. I apologize, I don't have it at the tip of my fingers. But I would say, under any analysis, whether it was because he hadn't been paid or what have you, a day of trial withdrawal allowed without a continuance operated an unfairness on the McDonoughs because they couldn't have been prepared. And the damage that this did to them is enormous. You look at Cambridge Realty, tenants are given the benefit, are given the opportunity to get a lawyer if they say, listen, I have a lawyer that's ready to go, I want to go in 2 weeks. It's been tough on landlords. This pandemic has been tough on landlords. It seems pretty unfair to give to tenants the opportunity to obtain counsel and not give the same opportunity to landlords when they represent that they're willing to get new counsel and to proceed with new counsel.
So counsel, this was pre-pandemic though, right?
Yeah, I guess I'm more thinking, I think on a certain level that this court is looking at the consequences of its decision. And, there's going to be some consequences for the small mom and pop landlord and for the, concurrently the real estate market. If this court says, no, we're fair to tenants, but we're not fair to landlords.
I do have another question, but I think Judge Desmond might.
That's okay. Go ahead, Judge Hammond.
Just focusing you on the trust issue, why was this representation of the trust not waived where the landlords never told the housing court until the trial had already commenced, where the landlords transferred the property because of this lawsuit, and where in any event, Mr. McDonough was in charge of maintaining the property for the trust?
I think it was not waived because functionally, Mr. McDonough was representing his wife. In his brief, my brother suggests that he was not, his representation of his wife was the same as Ms. Leone's representation of Mr. Lund, but that's not true. Mr. Rafel was there. And Mr. Rafel is a skilled advocate, as you're about to find out. And
Well, the record seems to at least reflect that the wife was there because it says the plaintiffs looked at that file. So why is it that he's representing her versus her choosing to stay silent?
because I think she was required as a pro se litigant to question her husband or to put forward some of her own defense. The judge attributed Mr. McDonough's defense to his wife, which I think was impermissible. The better course would have been to default Emer and then let Mr. McDonough proceed on his own, or in the alternative, to continue the trial, which is obviously what we're.
Why is this any different? I mean, or worse than a default? Here, at least somebody was trying to defend them.
Because a default would give a different kind of basis for an appeal. In so many senses, the McDonoughs got the worst of all possible worlds here. I think if I came to this court and I said my clients were defaulted on the day of trial because the court allowed their lawyer to withdraw, which is in a sense functionally what happened, I think it would be an easy case for Your Honor to say, look, we got to send it back. That's not justice. We favor a resolution on the merits here. And you know, instead they're stuck with this situation where he presented the most anemic of defenses, and you know, had obviously the comparative negligence issue no matter what, and you know, just didn't know to raise it. He fell off the roof of the law.
So we are going to, and I have two more questions, so I'm hoping you can keep your answers tight. You've been very good so far, and I'm sure Mr. Raphael will be too. The tenants argue that because Molly saw allegedly a Snapchat video, she would not have been in a position to testify as to the day the video was taken or whether Ms. Leone was injured in that video. What do you say to that?
I think that that's a question that the finder of fact should have had the opportunity to decide. I think she could have testified about the date that she saw the video, and the finder of fact could have assessed her credibility, and that may or may not have had an impact on the trial. But because Mr. McDonough just didn't know that she had to testify about it, he doesn't know what hearsay is. It didn't come in.
Okay, and then my other question is, and this really is to both parties, I have to admit you left me confused in the briefing. There seems to be multiple sets of stairs, and the injury occurred on the back stairs, if I understood you correctly, but there was an argument about whether or not the tenant was engaging in inappropriate horseplay by sliding down the front stairs. Is that
correct?
Okay, and so the issue is that the landlord was contending that she really was injured by sliding down the front stairs?
That's what my client believes, yes.
All right, thank you.
Thank you.
In that she had staged the rear stairs. The damage to the rear stairs, he suggests, was staged. Is that correct?
I think that's what he believes, yeah.
Oh, sorry, go ahead, Judge, please.
I was just going to ask one other question. When Attorney Phelps withdrew, the Leone assented to the motion to continue, correct?
I believe that she did.
Okay. And the case law tells us that the judge is to inquire as to the defendant with respect to the impact of the continuance on the trial day. Is that right?
Yeah, I think that's one of the three factors. Yes.
Thank you.
Thank you, Judge.
Any further questions, Justice Henry? Justice Desmond?
No, thank you.
No. Thank you, Attorney Jacobson. And we will now hear from Attorney Rafel, whose reputation precedes him. And Attorney Rafel, could you start by clarifying what was the reason why trial counsel withdrew immediately before trial, and where on the record can we find that, please?
Sure. If it may please the court, the trial counsel, Attorney O'Reilly, it indicated to first Justice Chaplin that he had some kind of a breakdown in communication with his client. That would be attached to both briefs, and it's in the record appendix, is the actual motion itself, Your Honor.
So, but I'm looking at that at page 39, and it just, so that's where he says that they were, now I see that they were not able to satisfy their financial obligations, but the affidavit doesn't say that. It says that there's a breakdown in the relationship.
So correct, Your Honor. So if I may clarify, 2 days prior to trial, or 3 days prior to trial, I received, and I'm sure that the court received, a facsimile from Attorney O'Reilly asking and praying for two prayers. One was a motion to continue the trial, and the other was a motion to withdraw. And you're right, Your Honor, in his motion to continue, he indicates that his clients were unable to satisfy his financial burden to his attorney. And he argued in his motion to withdraw that there was a breakdown of in communication. I think it's a little disingenuous, quite frankly, to ask for a continuance so that he could then try the case later when he gets paid, and at the same time seek a motion to withdraw, indicating that he has a breakdown in communication. But I suggest.
Well, I recognize you're in an awkward position because you are not Mr. O'Reilly, and perhaps he's the one who needs to be called to account here. But is there any indication that these people knew this was happening prior to the day of the trial? Because I don't see certificates of service here, which might actually be your learned colleague's responsibility, but we can't see this.
Sure, and I would just answer that question by similar to how Attorney Jacobson did. It was faxed to the court, and it was faxed to me 2 days prior. I can't say definitively whether or not Attorney O'Reilly, at the time that he faxed the motion to the court and to me, that he presented it to his client. But I would suggest that it's not the pale of imagination that he was having this conversation with his client more than 2 days prior to that facsimile, if his reason and his grounds was a breakdown in communication. I got to believe that he was preparing for trial. I got to believe that his client was doing the same. And I have to believe that before the fax was sent, there was a breakdown in communication in which, again, and I would be speculating that he would have told his client that this is what one of my options is. So
Attorney Jacobson argues to us that the trial judge should have just said, you cannot withdraw. And that's certainly something we see. And had this fellow go to trial, that would have been a better alternative than just letting him withdraw and leaving these people to fend for themselves. So why shouldn't that have been what happened here?
And sure, and I think, Your Honor, when you questioned Attorney Jacobson, hit the nail on the head. Well, why should a lawyer have to work for free? Is certainly one answer to that question, Your Honor. But more importantly, I think Judge Desmond also suggests that there was a pattern here. There was a pattern. He had 4 lawyers altogether, and each one withdrew for the same reason, for financial. Well, and one thing that really I hope strikes the court is that the McDonoughs or the McReynolds previous, when they initially filed the summary process action, they filed a motion to withdraw pro se for his previous attorney Phelps. It wasn't even Attorney Phelps's motion. They pro se requested to allow them to represent themselves at trial. Look, it's unfair for, is what he says, it's unfair for Attorney Phelps to have to work and not get paid. We'll do this ourselves like we started the process. Then,
where are you quoting in the record?
this is the motion to withdraw that was filed March 2, 2016. It's in the record, Your Honor.
Well, I'm trying to get, we can look at the record while you're arguing it, but I need a page number because it's not jumping out at me.
Let me see if I can find it for Your Honor. It's
I think it's in the addendum of the appellee's brief.
Thank you, Your Honor. So it's in the addendum to my brief, the last addendum, and it's entitled Plaintiff's Pro Se Motion to Withdraw, to allow Attorney Gerald Phelps to withdraw his appearance on behalf of plaintiffs Kevin and Emma McReynolds. And this was dated February 22, 2016, and it was signed both by Emma McReynolds and Kevin McReynolds, pro se. And it was argued, Your Honors, on March 2nd, 2016, 22 days prior to the case being specially assigned for a 2-day trial on March 24, 2016. 8 days later, the McReynolds or McDonough's now hired Attorney O'Reilly. So they say right before trial that they can't afford to pay counsel, and that we're gonna try the case on our own. 8 days later, they hire a fourth lawyer, Attorney O'Reilly, and Attorney O'Reilly comes in and asks for a continuance. And as a courtesy to, as I would give, any attorney, we didn't object to another attempt, what I would suggest, to stall the case again.
So, counsel, I would applaud your civility. I would like to see more civility among the bar.
Sure.
I do want to understand, though, a different issue on this, which is why I don't understand. There was a point in this case early on. So the landlord, it seems like, asked for a jury trial when they responded to the counterclaim. So right at the very beginning. And at that same time, the tenants were asking for a jury. So we have both parties asking for a jury. And then it seems like the housing court said, you're not getting a jury. Am I factually correct about that?
Yes, Your Honor.
And what if we have certainly plenty of case law that the judge has the discretion about late requests for a jury trial, but here we have both parties asking for a jury trial. Why can the judge exercise their discretion and say, no, you're not having a jury trial?
So that's a great question, Your Honor. And I would suggest to you that there is absolutely no discretion. Rule 8 of the Uniform Summary Process Rules states that a request for a jury trial must, it's not a may, it's a must, file that request before the answer is due. And I think my brother in his brief acknowledged that they don't have a leg to stand on this issue. And in fact, they're asking Your Honors to again revisit the seminal case of Senior Housing Properties Trust, the Senior Housing Properties Trust case, which the SJC already decided this issue. The exact same issue, in fact, not a different issue, not even a similar issue, the same issue. In the South Housing Properties Trust case, the court put this issue to bed. the court indicated that the Mass Rules of Civil Procedure, Rule 39B, absolutely does not revive a right to a jury trial that's been waived.
I have two questions. One, when counsel moved to withdraw on the day of trial, I'm just going to revisit that for a second. Did the court ask to hear from the McDonoughs or the McReynolds at that time?
You know, Judge, that's a great question. And my honest answer is I don't recall if they asked the McDonoughs. I know the judge had asked me, as judges do, but as far as whether or not they asked the McDonoughs, I can honestly say that I have no recollection one way or the other.
Okay. Do you have any recollection whether or not the McDonoughs, whether asked or on their own, objected to the attorney withdrawing and asked him to stay, make the court ask him to deny the motion?
So my recollection is wasn't until after the trial had commenced and during testimony that Mr. McDonough, when he got frustrated, would say to the judge that you know, that he wasn't prepared.
Okay. And then in the motion, the pro se motion, which they filed to allow Attorney Phelps to get out of the case, at no point in that document did they mention that they're now a trust.
That's accurate, Judge. The first time we learned that they were a trust was during cross-examination trial testimony. And you can see the record that they admitted on cross-examination that, and these are my words, that they surreptitiously transferred the deed to the property into the trust. And they testified under oath and under my cross-examination that they knew what they were doing. They did it for the purpose of protecting their assets from personal liability.
And they did that in August of 2015.
August 11th, to be exact, Your Honor.
And did anyone challenge, was there any challenge whatsoever at trial to their right or ability to represent the trust?
So I would suggest, Your Honor, that that they didn't represent the trust. The entire time the case was filed as individuals in the name of McReynolds. And once it came out after trial, I had moved to dismiss the plaintiff's complaint.
I understand procedurally how it worked. My question is, did anyone raise this issue before the trial judge? Or was this raised on the first time on appeal?
Oh, I understand your question. I believe it was raised the first time post-trial, procedurally, as we just mentioned, after my motion. But as far as to represent the trust, no, Your Honor. No, this is the first time it's been raised is on appeal.
So do we have the trust in the record? Do we have any idea who the beneficiaries are? Because I haven't seen it.
So, Your Honor, that was going to be my other question. My other point is that under Braxton, you know, even if you could argue that that at trial the trustees, he was a trustee representing the trust, he was the beneficiary. It was a nominal realty trust, and he put his name and his wife's name as trustees, and they were the beneficiaries, I believe, was the trial testimony.
So on the senior housing case, I want to understand if that case is procedurally on the same posture as this case. In other words, was it the plaintiff who did not ask for a jury trial, then received counterclaims, and then tried to ask, or was the issue that the defendant originally did not ask for a trial and then wanted one? I'm sure you will dig into the case in detail, but I wanted your take on what the case is about.
Sure. So again, my recollection of the case, Judge, is that this was a land court trial originally, and I believe it was not a counterclaim. I believe it was on the landlord's complaint itself. I hope I answered your question. I'm not sure if I did.
Well, it's certainly the beginning of the case is, as I look at it, is not exactly crystal clear about who is who. But we have the case, we will consider it. In the pretrial, I guess one other thing well, other things I'm troubled by, but here we have a decision we have a pretrial memo that the parties filed together where the landlords clearly raised the issue of comparative negligence. We have testimony both from the landlord and from your client, Ms. Leone, about the condition of the stairs. And yet I think that the judge did not mention comparative negligence in their memo, in the findings of fact and conclusions of law. Am I correct about that?
So I believe that the court in the findings of fact did indicate specifically that she weighed certain testimony regarding Mr. McDonough when he testified that he believed that it looked like it was set up, that he believed that she was horse playing at another time. I just, I don't think under the comparative negligence statute, well, I know I look at the comparative negligence statute, there's nothing in there that would require the judge to make specific findings on comparative negligence unless she actually felt that there was comparative negligence.
I think there's a difference between the horseplay, which is an alternative explanation for how she got hurt, and the fact that the tenant was saying from the beginning of the tenancy, this set of steps is not safe, and then she used that set of steps instead of using the other set of steps that I think I'm not clear, but that the other set of steps may not have had any issues. And that testimony does seem to be in the trial. And if it's in the judge's findings of facts and conclusions of law, I would really like you to point that out to us.
So if you look at page 66 in the statement of proceedings, the judge indicates Judge McDonough testified that he repaired the stairs in June of 2013 and that he had photos of the stairs he replaced, which were more than 5 stairs. He further testified that he did not replace the stair Ms. Leone broke. He testified that he saw the stairs on November 1, 2014, and that it was splintered in half. Mr. McDonough testified he did not see the stair needed repair prior to October 31, 2014. Mr. McDonough testified he did not replace the stair that splintered when he replaced the tread in the risers. Then on page 96 of the judge's findings, going into page 97, on the very bottom, the judge, in talking about causation, says the defendant, Barbara Leone, is not required to show the exact cause of her injuries or to exclude all possibility that they resulted without the fault of the defendant, Barbara Leone. The defendant, Barbara Leone, must show only the harm was more likely due to the plaintiff's negligence than to some other cause.
Let's just make this more general. Let's say that there are 2 sets of stairs into and out of a property, and one is the most beautiful, perfect set of stairs ever, completely safe, and one is decrepit and completely unsafe. And the tenant tells the landlord there's a completely unsafe set of safe set of stairs, and the landlord says, "Yeah, I know, but you should just use the the front steps. Those are totally safe." And the tenant, for whatever reason, just goes up and down the unsafe steps. What happens when the tenant is injured?
I would like to answer that question first by saying I don't believe that that's what the facts of the case are. But to answer your question, I'd certainly suggest that that would create more of a problem for the plaintiff trying to make a prima facie case, and would cause more of a problem for the fact finder to.
When you say the plaintiff, you mean the person who was injured, right?
Correct, Your Honor. Yes, the injured party. And also for a fact finder, whether it be judge or jury, to make a determination. But as the court is aware, this is not a case or where the court would revisit the findings of fact. I think that the law is very clear that the appeals courts. And I'm sure your honors have made this decision clear, when it comes to comes before you, that you're not in a position or not going to and can't revisit the findings of the trier of fact. The trier of fact heard all the evidence.
Right, but the issue here is, did the judge have an obligation to consider the doctrine of comparative negligence, which was quite clearly raised in the pretrial memo? The judge then discharged this attorney who would have known to use those buzzwords. And then I'm trying to figure out, but I don't see in the findings of fact and conclusions of law, and if I'm wrong, I really want you to tell me, I don't see that the judge actually addressed that issue. And that's concerning.
Sure. So I think you're right, Your Honor. The judge did not specifically state, I find no comparative negligence. But under the comparative negligence statute, she's not obligated to. In fact, under the comparative negligence statute, the burden is on the party that's making the comparative negligence argument to put forth that issue before the court. And quite frankly, Mr. McDonough did. Mr. McDonough had my client, Miss Leone, on the stand for almost a whole day, a half a day first day and a half a day the second day.
Counsel, we do understand that, and my colleagues are indulging me very much by letting us go past the expired time. And I also want to make sure you feel treated fairly, because I know we did ask the counsel for the McDonoughs. So I want to make sure you feel you made your points.
Thank you.
Okay. I mean, I do want to say you both have a lot to lose, and this is a case that cries out for perhaps you should consider talking to one another, because your client, Mr. Raphael, could win a lot more money potentially in a retrial. But on the other hand, there's some concern here about the fact that at a time when both clients want a jury trial, the judges, and we do deeply value that and have constitutional rights around it, and the judge is saying no. So this sometimes it's very clear we just have an issue of law. We need to decide this case. It seems like both sides have a lot at stake here, in both directions. But thank you for indulging me on that.
Thank you, Your Honor.
Seeing no further questions, I'd like to thank counsel for their presentations, for your briefing, and thank you both very much for your candor here at oral argument today. It's much appreciated by the court.
Thank you, Your Honor.
Thank you.
I apologize for the inconvenience.
Okay.
The case is now being recorded.
Welcome back to the December 15th, 2020 sitting of the Massachusetts Appeals Court. I'm Eric Nyman, sitting today with Justice Vicki Henry and Justice Kenneth Desmond. Calling the next case on our list, 2019 P1700, Doe versus Sex Offender Registry Board. We will hear first from counsel for Doe, and I would remind counsel that this case is impounded, so please refrain from using names. Attorney Nearing.
May it please the court, my name is Ilse Nearing and I represent Doe. My argument today, I would like to address some issues I see in the Sorb's brief. With regard to factor 2, The SORB argues that full weight applies to the threshold determination of factor 2. This argument must fail because logically and rationally, a threshold determination can't be at full weight. First of all, the word full doesn't appear in factor 2 to describe the weight given to the threshold determination when the offender had had time to reflect upon the wrongfulness of his conduct. And when we look at what does the word full mean, the Merriam-Webster says it means being at the highest or greatest degree, or it means containing as much or as many as possible. Well, if the threshold determination is the full weight, implying completeness and at the highest degree, then there's no more room for the next two determinations, which
let's say we agree with you, Attorney Nairn. Your sister says even if you had given that factor 2 nominal weight, there was still sufficient force to find him a level 3. What do you say in response to that?
I would say, but then that makes the application of the factor instrument just mechanical, without any, checking off the boxes and without any real reflection and of Doe's individual facts and circumstances, which are the due process protections afforded under the Massachusetts registry law. So even if there is a factor 2 or factor 1, hopefully under due process, there's going to be some really looking at the unique and individual facts of the case.
And you're not arguing that factor 2 is inapplicable. You're just quarreling with the degree that was of weight that was afforded it.
Well, the hearing examiner says he gives full weight.
I understand.
And full weight implies the full heavy weight. And he's at the threshold determination that he had time to reflect. So he hadn't been previously convicted or detected or charged.
But the question was, you don't take any issue with the hearing examiner applying the factor. You take issue with the degree of weight that he gave it.
Thank you.
Is that correct?
That is correct, because that's what was argued below.
Okay, can I ask you a couple sort of related questions? A lot of times when we see these cases, the hearing examiner will use the phrase, "this factor applies." Had the hearing examiner used that here with respect to factor 2, would you be raising the same issue, or would that have been sufficient?
Oh, I see the question. Well, then I would say that, well, how does this factor apply? Because there are 3 determinations: the threshold, the increased, and then the most weight, and it's left ambiguous.
Where do you come, the term threshold, where does that come from? I saw it in the Doe case that you cite here, Doe 22188, the recent case out of this court. But
Yes.
where does that term threshold come from? I don't see it in the statute or in the regulations.
I agree, it's not there, but in the particular case which was cited, that's the way they describe it, as the threshold, and then the increased, and then the most weight, the 3 determinations.
Okay, I was just wondering if there was any indication as to where our court drew that from.
I don't know.
been able to find it. Shoot. Okay.
So then to move on to my second issue is with regard to factor 16, the public place. The SORB seems to be arguing against a reading of the words of factor 16, and that argument must fail because the law is the words. The SORB is directing this court to Doe 136652 at 81 Mass Appeals Court. That's a 2012 case. And that case is distinguished from the case at bar and is not on point because the public place in 2012 was factor 9, and the wording was very different from the current factor 16. So that case is really not on point or relevant. And the SORB.
When the SORB changed its is your point that when the SORB changed its regulations in 2018, it changed the or to an and essentially?
correct. The original definition was much shorter than it is today, and the newer regulation is much larger and is including other words, including the expectation of privacy is added as well.
Am I correct that it also changed or to and?
Yes, I saw that.
Okay, and I guess my follow-up to that is, was the 2018 amended regulation in effect when this case was before the hearing examiner?
The regulations, to my knowledge, were amended in 2016.
Okay.
And that this factor 16 as it exists today was promulgated in 2016, and it was indeed the law at the time when Doe had his hearing.
Okay, that's helpful, thank you.
And the SORB is pointing to 2 Rule 128 decisions for the proposition that living rooms and bedrooms are public places. Those decisions are not dispositive because the issue before the court was not framed as whether factor 16 had 2 elements and if each of the 2 elements had been met. And the SORB is borrowing an argument from one of those decisions in 18P 1671 to argue that Epperson 2000's list of public places is not exhaustive. Well, that's not really the issue here, and it doesn't undercut the argument because the SORBs noticed scientific authority which informed their first prong comes from Epperson 2000, and that's any area maintained for and used by the public. And Epperson explains how the public item is applied to the facts. And if we go to the record appendix in the 2nd volume at page 64, it gives us examples of how this public place item is applied. And Epperson makes clear if the victim is kidnapped from a parking lot or a park and is brought inside a house or an apartment and the sex offense occurs there, then the sex offense didn't occur in a public place. And so the sex offense must occur in a room inside the house. So by the SORB's own scientific authority, houses and apartments are not public places for the first element, which is any area maintained for the public or any area used by the public. So
does it also include and any place that is open to the scrutiny of others or where there's no expectation of privacy? So when I read it, it says for purposes of factor 16, a public place includes any area maintained for or used by the public and any place that is open to the scrutiny of others or where there is no expectation of privacy. It includes both of those things.
So my understanding of regulatory interpretation is the and is conjunctive. So any area maintained for and used by the public is the first element, and second element is going to be either any place that is open to the scrutiny of others or disjunctive where there is no expectation of privacy. So the second element has 2 disjunctive possibilities, but the public place definition has a conjunctive and a conjunction in the and. So it's got to be a place maintained for and used by the public and any place that's open to the scrutiny of others, or in the second element where there's no expectation of privacy. That's
You're saying that anytime the situation is, say, in the living room or a family room, some gathering room in a house, that would, in a private house, that would not be sufficient to meet this because the public at large is not necessarily going to have access to that space?
Yes, I mean, that's what the language says in the factor, and the scientific research, which is supposed to be the foundation of this, is also saying that the impulse control is measured in public places outdoor that are open to the public, and all of this classification is in theory supposed to be based upon evidence, research of predicting the risk to reoffend. It's not punishment to say, well, that's unacceptable behavior and you really shouldn't be doing that sort of stuff in the living room. of the family house. That becomes punishment. That's not the scientific foundation of this.
But here the evidence was that the brother was in the room at the same time the sexual assaults were ongoing. So let's take a hypothetical. Doe commits a sex offense in the living room, and during the offense, it's a small room, and during the offense, there are family members and non-family members in there observing this horrible, odious offense. You're saying that there's a reasonable expectation of privacy there?
I'm saying that if this factor has the two elements with the conjunction, and it's based on the research that they're citing, public places are outdoors. Now, if you've definitely got the second element there with the brother arguably with the brother being there, but yes, if the relatives are there, then it's open to the scrutiny of others. But a public place by definition is open to the public and everybody. And if I understand the point, the measuring of the impulse control, but that's not how this is written, and that's not how it is in the research. And
well, if you look at the first sentence of Factor 16, it says adult male, the commission of a sex offense or engaging in sexual misconduct in a place where detection is likely reflects the offender's lack of impulse control. It doesn't say in a public place, it says in a place where detection is likely. The next sentence says the board may apply less weight to Factor 16 if there's evidence that the offender made a clear and concerted effort to conceal his offending behavior. Both of those seem applicable to this case.
I understand. And if this is based on scientific research to predict recidivism, then my argument is relying on the board's noticed authority. And it says public place. And if there aren't any more questions with that, then with regard to Factor 3, the board seems to be arguing that because the victim appeared to be 12 at some point, then Factor 3 merits full weight. Well, this argument must fail because what the board is proposing again is a mechanical application of Factor 3 to all 12-year-olds, which Factor 3 itself doesn't propose. It doesn't say that all children under the age of 13 are defined as prepubescent. The regulation says offenders who target prepubescent children generally younger than 13 years old, comma, and then that they are given greater weight. But if we look at the facts here in this case, this victim had breasts, and she was 12 and 13 years old, and under all colloquial or scientific understandings, post-pubescent females have breasts. And the evidence here didn't establish the proposition that this particular 12 or 13-year-old was prepubescent. Here, the hearing examiner ignored relevant facts about whether this 12 or 13-year-old was prepubescent. And the point of it says in this regulation that those who target prepubescents have deviant sexual interests. But this particular victim had breasts, and the sexual acts alleged weren't necessarily deviant. So that the argument is that the evidence wasn't legally sufficient for the application of Factor to establish by a preponderance the application of Factor 3. And I see my time is almost ended.
Seeing no further questions, thank you very much for your argument. We'll hear now from Attorney Nixon.
Thank you. May it please the court, Nicole Nixon, Assistant General Counsel, appearing on behalf of the appellee board. If I could move first to my argument regarding Factor 2. It's the board's position that the hearing examiner properly applied Factor 2 to his decision where he stated that he applied the factor with full weight. Now, I understand there's different ways to apply the factor and there's different manners of speaking. However, it's the board's position that when he says full weight, that means he applied it fully at the threshold weight. He didn't state that he applied increased aggravating weight or the most aggravating weight. He stated that he applied the factor with full weight, and that was appropriate based on the evidence that was presented at the hearing, which showed that the doe in this case sexually offended against the prepubescent child victim over the course of a year, approximately between 5 and 10 times. And he specifically found that the offender had opportunity.
Let me interrupt you, I'm sorry.
Sure.
Looking at the examiner's decision, at factor 9, just by way of example, this is the substance abuse factor. He said, I found this was a contributing factor and implicates this risk elevating factor. And then under factor 16, he said this risk elevating factor applies. And then in other points, he says, I give consideration to this mitigating factor. And in these cases, depending on which examiner we're reviewing, it seems that there is a lack of consistency oftentimes in the nomenclature. Am I incorrect about that?
Your Honor, that's a valid point to make. There is an apparent lack of consistency. I think, though, the way these factors are applied are based on the regulatory language of each factor. And if you look at, factor 16, say, what you took as an example, which says it applies, there's nothing within that factor specifically which talks about applying it with an increased weight. There is something that talks about applying it with a decreased weight, but I think the inference could be made that when somebody says the factor applies, then it applies to the decision at that threshold weight rather than a decreased weight. Going
back to factor 2, factor 2, at least as I understand the regulation, either it applies with increased weight, or it applies with the third category is, I'm forgetting right now.
I believe it states with the most aggravating weight, correct?
Right. In our case law, interpreting that uses the term threshold, and I asked your sister this. Do you know where the term threshold comes from?
I don't, Your Honor. It's not in the regulatory language. I think it came from DOE 22188, the appeals court decision, which talks about the different demarcations of weight in factor 2. It doesn't come from the specific regulatory language of factor 2.
And in that case, did the hearing examiner use the term full weight or a different term? I just don't recall.
Your Honor, I think they used full aggravating weight. So there was that term full in there. And I guess my larger point, or my better argument that I could make as to factor 2 is that even if you find that it was error to say that the factor applied with full weight, meaning full aggravating weight, the factor still applies at its threshold level. And so any error in the wording and I guess weight applied to factor 2 is harmless and doesn't affect the overall decision where there is substantial evidence to support that level 3 classification when that increased aggravating weight is taken out of the equation. Because we have, again, factor 2 would still apply at its threshold level. And we have a number of other high risk and risk elevating factors to support that level 3 classification. And if you specifically look to, I believe, DOE 23656, it's a case out of the SJC. They talk about harmless error, and if there is still substantial evidence to support a classification decision when the error is excised out of the equation, then the decision still must stand, and it doesn't require reversal. I would state that that's a situation that we have here, even if you do find that the wording of full weight was erroneous.
So, I mean, you're acknowledging there could be some ambiguity about what full means?
Yes.
Okay.
Candidly, yes.
I mean, if the factor is applied with the most aggravating weight, that by definition is the full weight, isn't it?
Yes, Your Honor, I would acknowledge that. And again, I would go to my second argument as to factor 2. Even if you find that the wording of full weight is erroneous and meant that he applied it at that most aggravating weight, that error was harmless in this situation where there's substantial evidence to support that level 3 classification when that increased aggravating weight is excised out of the equation.
If we agreed with you, and that really is a big if at this point, So this is purely hypothetical, but then we would move on and look at the hearing examiner's findings with regard to the other factors. So as I'm looking at the public place factor, I believe that's factor 9.
Factor 16.
Factor 16. Do you agree with your sister that the regulation was changed in 2016?
It was changed in 2016, Your Honor. The regulations as a whole were changed in 2016. There were amended factors that were promulgated, in 2016. And those 2016 regulations are the current regulations that are applied today and were applied in this case, which I believe was heard in 2017.
And did number 16 change from or to and? I know the changes are broader than that, but that seems to be the critical issue here.
Sure, Your Honor. And candidly, I'm not sure how the wording changed and the definition changed from 2012 to 2016. I mean, I think the important thing for your consideration here today is the application of the current language in the 2016 regulation. And even with that, I don't agree with my sister that creates a conjunctive test. And I don't believe that the case law has construed that regulatory definition to be a two-pronged test. Rather, it states that a public place can be an area that's maintained or used by the public, and as well an area that's open to the scrutiny of others or where there's no reasonable expectation of privacy. And I think the interpretation in that manner where any of these three different circumstances could make that area a public place is consistent with the regulation as a whole, which really looks to see whether there's a lack of impulse control, and somebody who commits a sexual offense in the presence of somebody else clearly exhibits that lack of impulse control.
But that's a place where actually your argument was a little confusing, because the whole idea was that the doe actually was entirely acting not on impulse, but in fact was creating a situation where everybody else, they were waiting it out. They were laying in wait, actually. They were premeditating what they were doing, and it's not a lack of impulse control because he was waiting for everyone else to go to sleep. So how does that reconcile?
That's true, Your Honor. However, I would state that he may have been waiting for everybody else to go to sleep in the house, but he still ended up committing a sexual offense on the victim while she was sleeping next to her brother on the same mattress. I acknowledge that the brother was sleeping at the time. However, he could have woken up at any time, and detection was likely where he was committing that sexual offense right next to the younger brother who was sleeping, and could have easily detected the activity that was occurring. And I would point Your Honors to a decision that recently came out of the appeals court. It's Doe number 390261 v. Sorb at 98 Mass Ave Court 219, and that's a 2020 decision. In circumstances that are pretty much exactly as to what we have here today, a panel of this court found that an area where somebody committed a sexual offense, where somebody was sleeping nearby, did constitute a public place because it was open to the scrutiny of others and lacked that reasonable expectation of privacy.
In that case, was the brother also?
I believe it was the brother also. Yes, correct. Okay. And it was very similar circumstances where they were sleeping in the same area or on the same mattress.
98 Mass Ave Court 219.
Correct. And I believe it was in October of 2020 was when the decision came out. And if Your Honors would like, I could submit a 16L letter with that site.
I think it's in the brief.
Yeah, no need, but my follow-up is that case, and I apologize, I just don't have that, but that case interpreted 803 CMR 1.33 16A, and specifically that definition of public place?
Correct, Your Honor. Yep, it's that 2016 iteration of public place.
So under this theory, though, about the public place, I mean, if you have an assault that occurs in the victim's bedroom, then I guess my question is whether the bedroom is a public place in the sense that if it's on a common hallway, right? Because in other words, you'd have this risk of detection coming in and out of the bedroom, because many houses, if not most houses, are laid out where the bedrooms are all clustered together. And under the way you're describing it, then that would be a public place too, even though nobody else was in the actual bedroom.
Your Honor, I think that would be a closer question, certainly. We have here the presence of an actual person in the area where their sexual offense was occurring. So I think that's why it squarely falls in within the definition of a public place. I think it's a closer question whether a bedroom where a door is closed and somebody could be walking by and hear it would constitute a public place. I'm not sure if it would. But I think the circumstances here certainly fit within the realm of a public place where, again, we have the presence of a person in the same area where the sexual assault occurred.
Could you address Attorney Nearing's argument regarding the prepubescent element?
Sure. And I think, the hearing examiner was well within his authority to apply factor 3 with increased weight here, where the evidence clearly shows that the victim was 12 years old during some of the sexual offending time period. The regulation states that a prepubescent child defined, at least under the regulation, as somebody who's generally under 13 years old. Here, we clearly have that the victim was 12 years old when the sexual assaults began. So the hearing examiner reasonably applied it with increased weight where she was 12 years old when that sexual offending behavior began, and she fell within that definition of prepubescent.
Are we, I guess the threshold question, to use the word threshold, is, are we considering a strict age situation, or are we considering the specific development of the victim?
Sure, and the regulation admittedly states generally children under 13 years old. So I think there is some room to argue there. But the way the regulation has been applied is generally, if somebody's within that under 13 age range, they're considered prepubescent. I would also state that there isn't really any evidence to support my sister's argument that the victim here was so developed that she would not be considered a prepubescent victim. There was some evidence to suggest that part of the sexual offending was, touching the victim's breasts, but we don't have any indication of how developed those breasts were, or if that put her over the threshold of being a pubescent or a post-pubescent at that point in time.
But whose burden is that? Isn't it Sorb's version to put forth evidence that shows that she was prepubescent? The evidence you have is, well, the evidence is clear that she was 12 at the time. That in and of itself, I mean, I don't know that constitutes a presumption. It's close to it, but not quite, I think, under the regulation.
I don't think it constitutes a presumption as well, Your Honor. And I acknowledge that it is Sorb's burden to put forth, the evidence to prove its case by clear and convincing evidence. Subsidiary facts are proven beyond a preponderance of the evidence. And I think here, where we have that age of 12 years old, that clearly falls within the realm of reasonableness for the hearing examiner to apply the regulatory definition here, and to say that increased weight was warranted because she was at that 12 years old threshold range.
God, let me let you finish your answer.
Oh, no, go ahead, Your Honor.
So why use the word generally then?
That's a fair point, Your Honor. I think that the generally is in there to provide the hearing examiners with the discretion to apply it accordingly. There may be cases where there's a lot of evidence to suggest that a particular victim is more developed, I guess you could say, at age 12. I don't think that that's the case here. I don't think that we have that. I think it's an assumption that's made by my sister to say that the features of this particular victim were so developed as to take her out of that threshold prepubescent age.
Is there anything I don't think it would take much to satisfy that element on Sorb's part, but is there anything in the record that does that? I mean, a reference in the police report or a statement that said, she was a 12-year-old kid or something to that effect. I mean, is there anything anywhere in the record that we should look to?
There is, Your Honor, and I would point to the police reports, which detail the victim's statement as well as the mother's statement and the father's statement. And in all of these statements, they identify this girl as a child and a girl. And I think there, you can make the determination based on those characterizations as well as her age at the time that she does fall within that prepubescent category.
Notwithstanding that, it does say that throughout many of these instances, he fondled her breast. Isn't that in the record?
That is in the record, correct, Your Honor. However, I mean, I'm not sure. anatomically speaking, if I may, Your Honor, somebody has breasts at any period of their life. It's just as to whether those breasts are developed or not. So I think that the word breast in there doesn't necessarily negate the fact that she is a prepubescent victim.
One other question for me anyway. Doe argues there was no indication he was using narcotics during the acts of abuse, as opposed to just generally using narcotics during the like 13 months or time period that was of the period of abuse. What do you say to that?
Yes, Your Honor, and there isn't a specific indication where he admitted to using narcotics while he was sexually assaulting the victim. He denies that he sexually assaulted the victim. He did admit, however, that he was using various narcotics during the same time period in which the victim stated that she was sexually assaulted. And the hearing examiner, based on both of these pieces of evidence, reasonably inferred that substance use was a contributing factor in that sexual misconduct.
Why else would he voluntarily disclose that?
I'm not sure I understand your question, Your Honor.
Why else would Doe say that, oh, and by the way, during I didn't do it, but by the way, during that time, I was a heavy drug user?
I'm not sure why he voluntarily disclosed the fact that he was using drugs. I wasn't in his mind when he was, speaking with the police. But I think, the evidence that we do have to look at supports the hearing examiner's conclusion that the substance use was a contributing factor in the sexual misconduct.
If there are any further questions from the panel? Seeing none, the case is submitted. I just want to thank counsel for their excellent arguments and very helpful briefing. Both parties, thank
you. May I begin, Your Honors?
Not yet.
Thank you.
Mr.
Now being recorded.
Thank you, Mr. Cutting. Welcome again to the December 15th, 2020 sitting of the Massachusetts Appeals Court. I'm Eric Nyman, sitting again with Justices Vicki Henry and Kenneth Desmond. Now calling case 2019 P1845, Department of Children and Families versus Mother. We will hear first from counsel for the appellant, Attorney Sirotkin Butler.
Thank you, Your Honor. Since it was suggested we cut directly to the issues, I'm going to mention a case that had not been decided when I briefed, which is Shack versus Shack. In Shack, the Supreme Judicial Court made a statement that applies to the black letter law due process jurisdictional issues in this case, namely that concern for future harm is not the equivalent of harm itself.
You have a cite for the case?
I do, 484 Mass 658. It's right here.
Thank you, Your Honor. And in a way, that echoes the concern in adoption of IRIS, which I briefed and argued long ago. IRIS is similar to this case in having a regrettably sparse record. And IRIS, in fact, built that argument going all the way back to Santosky versus Kramer, and the statement that undue uncertainty as to potentially dispositive facts cannot be allowed, and in that case, it was a termination case, because the right to counsel in multiple hearings in a termination case does not suffice to protect fundamental liberty interests in the event there's undue uncertainty with regard to dispositive facts. That's 758 in Santosky. A major concern in this case is that the reason for finding my client not currently fit, finding her unfit or unable, were allegations with regard to her mental health. And mental health is problematic in these cases for the reason that there is a stigma issue in it. As soon as mental health is raised, it's almost as if the burden is being shifted to the parent to prove themselves well. And in this particular case, you can't use 51As to prove facts. George and other cases are absolutely clear about that.
The 51As were properly admitted, or do you quarrel with that, Attorney Swarkenbach?
Oh, no, they were admitted to set the stage, but they don't suffice for potentially dispositive fact to be proven. You can't use them that way.
Did your client make any admissions that she had mental health issues?
What she said was that she had had an episode of what she called delirious mania. Is she a doctor? No. Did she appear to suffer from that when she testified at trial? No. She was coherent. She followed instructions. She did not dysregulate in any degree. She was obviously not an educated woman, and she, in fact, participated in a partial hospitalization program, which, if anything, should count to her credit. But the fact that someone had had a past episode of some nature doesn't mean they're never capable of parenting.
Okay. So do you concede that she was involuntarily committed, at least on one occasion, likely twice?
Your Honor, I will concede that she was taken away by ambulance, but there is no discharge summary. There is no confirmation that she met hospital level of care once she arrived. There's no validation by any doctor or even a single page of medical records as to a diagnosis. And interestingly here, her rights were not terminated, and all of the children, according to their attorney anyway, wanted to maintain relationships with her.
There was some issue with respect to her staying on her medications, and she testified, I believe, that she no longer needed the medication. She wasn't using them anymore. And the record reflected that some of those medications included Risperdal and lithium. How are we to use that evidence?
What she, in fact, stated that was that the medications caused hallucinations, and there were no current prescriptions, and there was not a single medical provider who testified to mother having a current need for the medications. In addition, it should be pointed out that DCF didn't have custody of any of the children, and at the second volume transcript, page 35, DCF stated it didn't, in fact, have protective concerns, and they would have preferred that the case be dismissed and that the fathers have custody in probate court. Unfortunately, I don't have any information as to whether that was done or not. One of the difficulties in these cases is when I represent a parent, DCF provides little, if any, evidence, or usually none. And I don't know what these excellent fathers did. Mother took the position in her brief that the fathers were competent.
Does the court have the power to say that she can't visit them? I mean, jurisdictionally, is that within its authority?
Your Honor, the judge had the authority under adoption of John to find a bond, and there is evidence, and strong evidence in this record, that the children were raised most of their lives by mother, that while her choices as to educational advocacy might not have been the same that a social worker would make, she was vigorous in their lives, that the children wanted to see her. But according to John, the judge should have made a finding one way or the other about the bond and didn't.
What evidence do you point to suggest a strong bond beyond she raised them for many years in the early parts of their life?
And that they wanted to see her, and that when she was put on the stand, she was able to say what her activities with them were, what their favorite activities were, what their temperaments and personalities were like, all without any dysregulation or loss of continuity in her speech.
Do those things point to a bond?
Interrupt. She showed that she knew them, she knew their ways, that she gave her understanding of who was shy, who was outgoing, who was interested in math. Their attorneys made clear that they did want to see her and have a relationship with her. And if there had been some peculiar behaviors in the past, to say the documentation was not what is usual as credible evidence is being kind. The record is really very scanty. I don't know why none of the father's attorneys subpoenaed in any medical records. I really do not. I do not know why none of the father's attorneys provided evidence of the work they were doing in the probate courts, and I hope they do today. This is really a lot like a paternity case in probate court, but the juvenile court really isn't equipped to do them and to manage visitation for 10 or 15 years like a probate court does every day.
What do you say the correlation between unavailable and unfit is, if any?
Unfit is almost a moral term. And one of the difficulties that we deal with here is, unlike, say, Connecticut, or for that matter, North Carolina, our statutes don't define unfit. We go all the way back to the 1936 case, Richards v. Forrest, which talks about unavailable and poorly suited in order to cumulatively become unfit. I don't see anything in this record that says mother could not visit her children safely or be supervised by one of the fathers, at least initially. In the probate court, when a parent has had medical issues, whether they were a joint replacement or a mental health episode that resolved, the probate court allows for modifications, allows for visitation motions, and visitation can be adjusted over time as children get older and as parents progress in their lives. The juvenile really isn't set up to do that.
Was there an instance when father's supervision was required for visitation, and when mom visited, it didn't go very well, and she seemed to ignore father's supervision?
I think there is some material in the file to that effect. However, whether that material rises to the level of ordinarily admissible, credible evidence, I would contest that. I really would. This is a case which, if it were in probate court, properly have had a guardian ad litem for visitation and some assistance in setting up visitation. The juvenile courts are really not equipped to do that. They're for short-term emergency resolution. The majority of their cases, to my understanding anyway, result in reunification and closure, whereas a probate court case can come back until the children are 26 and done with college, and they have the expertise to deal with them. This is a case where there should be a remand to determine the probate court status with regard to these children, and to have a proper finding on the bond, and to see where, despite the passage of time, my client is. It is also true that my client has spent considerable time in Puerto Rico. After the hurricane there, our family house was destroyed and a number of family members went back there to rebuild it. And there is the typical scanty information here in terms of why was she in Puerto Rico so long after Hurricane Maria. This case suffers from an insufficient record, from, I would admit, my client having a burden shifted to her to show that she was not mentally ill at the moment.
Let me ask you one question, if I may interrupt. You rely heavily on adoption. You rely heavily on adoption of Iris, and at least in one of the briefs, the argument was that Iris was distinguishable on a few bases, and specifically, one quoting from the case that in that case, the unfitness finding, quote, depended almost entirely upon the one incident of serious and unexplained injury, end quote, to the child who was an infant, and that there the judge only made 31 findings of fact, and that the unfitness finding rested solely on one isolated incident, whereas this case, the judge made 94 findings of fact, there were 30 exhibits, you had mother's testimony, and you had additional indicia of the mother's struggles. Why is that alleged distinction either incorrect or not material here?
There were 59 findings of fact, very few of which were about mother in this case. And in terms of what was similar about the cases, it was the lack of inclusion of medical records to support the findings made. That was directly analogous. Regrettably, for example, in Iris, the actual children's hospital records and the actual doctors with different opinions did not testify. I know Iris all too well because I briefed and argued it. In this case, none of the medical records, whether from the partial hospitalization, what occurred after the section, what doctors treated her, again, none of that evidence, which would have been desirable to help the judge, was in. In addition, none of the attorneys updated the court in terms of what kind of actions were being taken in the probate court, because once this case is over, there is still parenting and co-parenting of some kind for quite a number of years that is going to occur.
In Iris, the parents had no prior history, and the injury to the child occurred with no witnesses and could have equally have been an accident. Isn't that what the case said?
It did indeed. However, because of the records unsupported by testimony brought in, there was various comments by doctors who then were not subpoenaed and were not subject to cross-examination. Here, we have a similar situation where unnamed persons are quoted, and even under the Luke protocol, because they're not identified, they couldn't be subpoenaed. So this case, while no two cases are identical, suffers from the reality that the record available on appeal and to the judge was scanty.
Was the advantage to your client of proceeding in this format that she got counsel, whereas in the probate and family court, she would not have?
That is beyond where I could potentially speculate. For example, in the probate and family court, one, there are the help centers that assist you with completing your complaints and documents. Two, Harvard, BC, BU, and Northeastern all have family law clinics in addition to what is available through legal services. I know that I had a family law clinic attorney on the other side of one of my interstate probate cases, and I came in on a motion and they came in with 53 pages because it was a team of the second and third year students who were absolutely fascinated by 28 USC 1738B and apparently had a lot of time to devote to it. So while there isn't a right to counsel, the more unusual a client in a case, the possible that a clinic will take it on. And that is about as far as I can speculate on that one.
Thank you very much. Ms. Make sure, are there any further questions from Justice Henry or Justice Desmond? No. Thank you very much, Attorney Butler. And we will now hear from, first we will hear from Attorney Hale.
May it please the court, Andrew Hale for DCF. If I could just begin with this evidentiary question. So the bulk of the evidence in this case came through DCF reports, which are admissible under Chapter 119, Section 21A, and the framework for that, their admissibility is laid out in Adoption of Luke as the parties discuss in those papers. I should note up front, Mother never challenged the admission of this evidence in the trial court. There's no objection at all, and so any objection at this point would be waived. Number two, under Adoption of Luke, second level hearsay within those reports is admissible so long as there is a source identified in the report, and that source would presumably be available for cross-examination if a party wishes to do so. That is the case here. So the evidence of mental illness did come in through those DCF reports, and we have specifically identified sources such as Mother's therapist, Emily LaPiccolo, and her psychiatrist, Dr. Mello, of North Suffolk Health, who were identified in those reports. Again, Mother did not seek to call them for cross-examination at trial, nor did she challenge the admission of that evidence. And so that is where we get the evidence of Mother's mental illness, her diagnoses, her hospitalizations, and so forth.
Do you agree with the statement in Mother's brief that DCF could have subpoenaed the medical records and treating physicians?
Yes, I do agree with that statement, Your Honor.
Okay, why not bring in the medical records? I understand that these cases can be tried based upon records and some hearsay information, etc. But where the gravamen of the case is Mother's mental status, why not? Why wasn't that done here?
Your Honor, I can't speculate as to the intentions of trial counsel and so forth. I would point out a couple of things.
Preferable. How's that?
I think in a perfect world, Your Honor, that certainly would have been preferable. In this case, if the challenge is that there, as Mother asserts, that there is no specific evidence of Mother's mental illness, that is incorrect. We have both evidence that comes in of her specific diagnoses and of her conduct over years. We have her found 911, somebody calls 911 because she's wandering Revere Beach talking to her children who are not present. We have an involuntary hospitalization under Chapter 123, Section 12. There's an emergency hearing called custody is transferred to the fathers because Mother is involuntarily hospitalized because she hasn't gotten her mental illness under control. We have a situation where Mother attacks her daughter on the way to the bus stop during a visit. We have another where she refuses to leave a visit with one of the fathers.
We're very familiar with the evidence. So, but my question, just like I said, it's a little different, and it's, well, I've asked it, but is it problematic, by the way, in cases of this nature to obtain such medical records in your experience?
Your Honor, I'm not aware of that it's problematic. I honestly can't speak to it, Your Honor, as a an appellate attorney for the Attorney General's office. I'm not DCF trial counsel, and perhaps my co-counsel could speak a little further to the kind of the practical nature of that. In this case, both the evidence and combined with mother's conduct over many years does provide sufficient evidence of mother's mental illness. And the issue is, as the court is aware, is there's a nexus there. It's not just that she's mentally ill, it's a nexus to her ability to parent. And that too is on display again with these incidents of attacking her child. There's one where she's on a visit, she's talking to a wall and so forth. So that nexus was clearly there in this case. If I could just briefly address that question of unavailability. So as the SJC said in Aaron, unavailability is comparable to being declared unfit. And in this case, the judge found both, made a finding of unfitness and a finding of unavailability. It doesn't relate solely to mother's physical unavailability, which I think mother sort of gets at in her brief. Of course, the mother was physically there at trial and she did testify, but this finding of unavailability relates sort of more deeply to this question of whether she's available to meet the needs of her children. And in this case, evidence, again, the mental illness, the fact that she could not maintain a sanitary environment for her kids, the fact that her kids couldn't get to school on time, that there was issues around their hygiene and lice and so forth, show that mother was just unavailable to kind of meet their needs in the way that they needed.
So if her situation changes, can she go back to the court?
Yes, Your Honor. Mother's parental rights were not terminated, and she does retain a right to review and redetermination under Chapter 119, Section 26C. So again, there's a right to that every 6 months, and mother could move the court to have custody restored. Seeing no further questions, I'll rest on my brief.
Excellent. Thank you, Attorney Hale. We will now hear from Attorney Bonardi. And Attorney Bonardi, as discussed, you have 2.5 minutes. However, our clock will start at 3 minutes and the red light will go on when there are 30 seconds left. Okay?
Thank you.
Thank you.
Good afternoon. If it please the court, I'm Christine Bonardi and I represent the father of A and Z. A was 12 years old at the time of trial and Z was 11 years old at the time of trial. We're requesting that this court affirm the decision of the trial court finding mother unfit and unavailable and ordering permanent custody of A and Z to their father. The trial court paid close attention to the evidence in this case, made 30 pages of findings, 94 findings, and mother only challenged 8 of those findings. The remaining uncontested facts show clearly and convincingly that mother's untreated mental health issues interfere with her ability to provide even minimal care of A and Z. Mother has a lengthy history, as you've heard from counsel for the department, starting in March of 2013 and continuing through the time of trial in March of 2019, of neglecting her children due to her mental health issues. A question was asked earlier about bringing in medical records. Mother clearly self-reported in 2013 in Record Appendix 1, Volume 1, page 150, she self-reported her own mental health issues. She stated that she had a diagnosis of anxiety, depression, and PTSD. Mother, throughout the course of this case, since 2013 actually, had exhibited her inability to parent these children safely. There are a number of different instances, as you know from our briefs, that mother failed to contact the schools when the schools were trying to get in touch with her. Even after the court had granted mother conditional custody in 2016 through 2017, mother continued to not follow through with the services that were necessary for her children. The oldest child needed mental health services. She had tried to commit suicide. She had brought something to school to do so. The school set up services for her. Mother didn't follow through. The after-school program tried to contact mother regarding my client's 2 children. Mother did not follow through with the after-school program. Father was contacted when there were issues, and my client followed through with what was needed. The question of visitation was also raised, but it was not raised at the trial level. If there are any further questions, I just ask that the court affirm the decision. Thank you. Fast 2.5 minutes.
we will rely on your comprehensive brief, which we've already read, and thank you very much. Seeing no further questions, we will go to Mr. Grammel. And
Thank you.
Mr. Grammel, you have, again, 2.5 minutes, but the clock will start at 3 and end at 30 seconds. So please go ahead.
Good afternoon, and may it please the panel. My name is Sean Grammel, and I represent one of the appellee dads on appeal, Father L. He asked that you affirm the lower court's decision. The mother was unfit because of her lengthy history of unmet mental health needs. No one disputed that my client was unfit at trial. He had taken good care of his son for 2 years on his own, while under the supervision of both the DCF and the juvenile courts. Then the question becomes, did the court abuse its discretion in finding mother unfit? Your Honors have heard about the hospitalizations, her refusal to take medication, to go to therapy, to see her psychiatrist. But all of these mental health needs, you can see in the record, it really affected the kids. And I think the strongest example of that comes in the summer of 2016, after she got custody back. The other father's 2 kids read a program, and they started having some concerning behaviors. The son was fighting the other kids, and they asked him, "Why are you doing this?" And he said, "My mom went crazy last night and left and didn't come back." At the same time, the daughter was having bathroom accidents at the program at 9 years old. Just a few weeks after that was when mother was first hospitalized. And those concerning behaviors and lack of supervision continued through the fall of 2016. There were several occasions when my client had to step in to do things for the kids that really mother should have done. She didn't even sign them up for school for the entire year. My client had to step in at the last minute and do that. In November of 2016, the kids had bed bug bites. They couldn't go to the doctor because they didn't have any clean clothing. So my client had to go and do the laundry so he could actually go to the doctor. And then a few months after that was when she lost custody after her second hospitalization. I'd just like to talk about the visitation piece quickly. Mother does retain the right for R&R every 6 months. She could also file for visits. If she wasn't receiving them, she can go back into juvenile court. She retains that right. So she can file a motion for visitation. She could also go to probate court. She still has her parental rights. And so there are a few different options for her here because this isn't a termination case. And it's my understanding that for CPCS, that would be a collateral representation. So there could be some, I'm not sure exactly, but there could be some ability for a lawyer to represent mom in those proceedings and the fathers. And if there are no questions, I will rest on my brief. Thank you.
Thank you. Seeing none, thank you, counsel. Finally, we will hear from Attorney Don.
Good afternoon. May it please the court, Andrew Don on behalf of the subject children. I have a lot of empathy with Attorney Sirotkin Butler's arguments. It is difficult to represent parents in the juvenile court for the reasons that Attorney Sirotkin Butler is sort of referring to. However, this is the scheme that has been endorsed by the Supreme Judicial Court in adoption of Luke, and there's no indication here or argument that the judge abused his discretion or committed a clear error of law in making the findings of neglect and unavailability on the mother here. I think it's important to remember here that rebuttal is not the same thing as a burden shift. So that these undisputed, unobjected to facts that came through mother's testimony, that came through the 51B documents, that are in the court investigations reports, that are in all the exhibits that came in, these could be rebutted by mother, but were not rebutted by mother. And that's not the same thing as a burden shift.
That being said, do you agree that the strongest evidence, the best evidence as to her mental health would have been the medical records?
Yes, it would have been. However, the evidence that was actually submitted is sufficient. But what's most important really here is the uncontested uncontested evidence of neglect of these children by the mother. And there's a lot of that. This is not scanty evidence. It's the neglect of these children that were in her care. Whether in the end that can be specifically tied to her mental health or not, I think it's a secondary issue, just to the fact of her neglect. And so that the mother was unavailable to care for these children by a whole track record of many, many years of one incident after the other of neglect of these children. And therefore, the judge finding her unavailable was not a clear error of law or abuse of his discretion. If I could just address the issue about visitation as well. Although the judge declined to make a specific order about visitation, he did not order no visitation. He left the visitation in the discretion of the fathers, and that these are fathers, not foster parents, not the department, not pre-adoptive parents, but fathers who were not strangers to the mother. They know this woman, obviously, and that they left their discretion for these visits in their discretion. So again, I don't think that the judge committed a clear error of law or abuse of discretion in declining to make a specific order about visits, but rather left it in the discretion of these fathers who knew mother and were in the best position to make judgments at any given time about whether the visits were in the children's best interest. And again, as has already been stated, the mother can go back to the juvenile court if she has a complaint about visitation under 119 section 26 in care and protection of Aaron. She can ask for a further order if it was necessary, but there's nothing on the record that indicates that it was. Those are all the points that I wish to address. If no one has any questions, then I would otherwise rest on my brief.
Just check, Judge Henry, Judge Desmond.
Nothing additional.
Thank you.
No further questions. Thank you very much. I'd like to thank all counsel. Very helpful briefs, very professional arguments. Thank you all very much. The case is submitted, and this concludes our sitting today. Thank you.